You have dismissed the appeal.
I agree.
Item 2 for orders.
I want to mention your lordship. May I make a mention, your lordship? There is a typographical error in the order 4/4/2024 passed in this case wherein before the was titled WPC number 7510 of 2023 has been typed in place of CONTC 7510 of 2023. Stop. The said order dated 4/4/2024 shall be treated to have been passed in the present case. Stop. WPC number 7510 of 2023 typed in the said order dated 4/4/2024 shall be read as CONTC number 7510 of 2023.
My lord, on 26/2/2024, my lord granted me till adjournment till date and also granted me that opportunity to proceed. We have proceeded. The second so-called notice has been issued and it is fixed to next week, my lord.
No date has been fixed. Though notice has been issued, no date has been fixed as yet. I don't know since when I will appear before the authority. The notice is with me, sir.
When do you want to appear?
No, they have not given any date. Though the notice
Mr.
is
Ponda,
there.
Mr. Ponda,
Sir,
please follow the query. When will you appear? When
Because-
do you propose to appear?
any day they
You
call me
give a
and I am ready to appear. But they
give a
have
date.
not given the date. This
Mr.
is the
Ponda,
notice.
you give a date.
Why
Sir?
are you so excited, Mr.?
No, not excited. Not sir excited.
Let us, we have not understood anything. He says that
Only-
notice has been issued,
Yes,
some date has been
Now,
given, you
sir,
are saying,
sir,
please wait,
sir.
please let him complete,
sir.
let him complete. It's a departmental proceeding.
Yes, sir.
In the departmental proceeding, second so-called notice has been issued.
My lord.
All right. So he has been asked to appear.
My lord.
Do you have the communication?
My lord, I don't have the communication.
I-
I have the, please.
Just, please don't interfere.
Sir.
So I am praying right now, my lord, 2 weeks time, so that I will come up to this honorable court saying that the departmental proceeding has been concluded.
All right. When, what is the date fixed?
My lord, actually the date fixed has not been intimated.
All right. What is there in the order? Please read.
My lord. Office of the Block Education Officer Korei, office order number no mention, date not mentioned. Sri Lakshmidhar Dehuri, OES 2 SB, Headmaster NC High School, is appointed as an inquiry officer to inquire into the matter of Duryodhan Sahu, the assistant teacher, Batula Government Primary School, Batula, subject to the charges laid down on him. Sri Sahu was also instructed to submit his written statement. In the matter, he has charged the submitted the inquiry. He has charged and submitted. The inquiry must be completed by 30/4/2024. And all formalities should be taken up accordingly to the rule. Srimati Kalpana Mohanty, ABEO member, Sri Vijay Kumar Malik, ABEO member, Sri Ramachandra Sahu, junior assistant, is appointed as the marshalling officer. This is there. No date has been fixed since when I want to appear.
What is the date? What is the date of that communication?
Date of communications are 16/4/2024.
Whether proceeding has been initiated or the data shows that one inquiry officer has been
A
appointed.
committee has been constituted, my lord. Inquiry committee has been constituted. The petitioner has been asked, writ petitioner has been asked to produce the original of the university certificate.
Original of the
University certificate.
university certificate. You give a date.
My lord, 2 weeks time may be granted.
Tomorrow tell us What is the date?
My lord.
Tomorrow he'll
Sir.
and bring the letter here so that that can be.
It is the letter, sir. I got the letter.
Another letter you will get.
Sir.
Item number 2.
Item number 2, last occasion I suggested to put up the matter of next week. I'll take instruction. I could not receive, my lord. Let's not keep it.
My learned friend will definitely address on that to my lord's my lord. Last date, one interesting point was raised by my learned friend, which has led me to make some endeavor. That whether the revision petitioner had a right to file rejoinder before the revisional authority. It's a case, my lord, that lapsing order, where there was an interim order passed by the revisional authority. State government took almost 1 year time to file a counter. After filing of counter, it was for the first time fixed before the revisional authority. Lord, I have a right of filing rejoinder. Under Rule 36 of 2016 rules, 30 days time should be given to me for the purpose of filing of rejoinder, and rejoinder will form part of the records. That is what the rule says, my. If your lordship sees Rule 35 and 36. I am grateful to my learned friend, Mr. Padhi. He raised this issue and I made the endeavor to see. Kindly see, my. Rule 36. 2016.
Amendment.
Yes. I have made a photocopy of the your lordship. Lord, may I be permitted to place it, man? Rule 36(1).
Yes.
On receipt of an application for revision under Rule 35, copies thereof shall be sent to the state government or other authority and to all implicated parties, calling upon them to make such comments as they may like to make within 3 months from the date of issue of the communication. And the state government or other authority and the implicated parties, while furnishing comments to the central government, shall simultaneously endorse a copy of the comment to the other parties. 2. Comment received from any party under Sub-Rule 1 shall be sent to the other party for making further comments as they may like to make within 1 month from the date of issue of communication, and the parties making further comments shall send them all to the other parties. The revision application, the communications containing comments and counter comments referred to in Sub-Rule 1 and 2 shall constitute the record of the case. After considering records under Sub-Rule 3, the central government may confirm or modify set-aside order not relevant for the purpose. But here, your lordship, see, they filed the counter on 26th of February 24. After taking almost 22/9/23, they were asked to file counter. They filed it on 26th February 24. That is beyond 3 months period provided in the rules. And it was for the first time listed on 12th of March. I asked some time to give me time to file a rejoinder, because which is permitted under rules. But on the same day, the revisional authority vacated the stay order, the interim order. Even that was the 30 days period was not even over. If your lordship see 26/2/24, it was listed on 12th of March. 30 days period was not even over.
What order was passed by this?
Lord, kindly see page 34. Lord, yes.
2024.
Lord, 12/3, it is page 15, man. Kindly see page 15, Lord.
Have you filed your rejoinder?
Lord, my instruction is my rejoinder is ready. Next date is fixed on.
No,
2nd.
we have observed that you can file.
Yes, my lord. I took instruction from my client. They have kept it ready. The next date they will file it.
No. In the meanwhile, list this matter on 22/4/2020.
Correct, my lordship has observed it. I beg apology, my lord. I instructed my client, my lord. They have made it ready. They will file it on the next. They have made it ready, man. Next date they will file it, man.
So they will decide.
They decide, my lord, only this, my lord, the consequence, if your lordship would kindly see page 34. That is the problem for me to approach my lords. Otherwise, I would not have troubled my lords. That position. Page 17, my lord. But I would not have trouble, my lords, unless this, my lord, would have been issued. I would not have trouble, my lords. As a consequence of that impugned order, this has been issued. If they come, my lord, annexure 2, they complete it, my lord, then my revision completely become infructuous. There will be nothing, because they will take over possession of my minds. There will be nothing remaining for me to do it in the revision. It will become infructuous.
Yes.
So this letter and order annex 2, page 17, is of February 2024. And the impugned order is subsequent to this letter, not that this letter is consequent to the order passed by the regional authority. And there you will also see notice was issued. You were requested to appear in person. There was no direction for any coercive action.
So do you say that no coercive action shall be
So
taken?
that I cannot make a statement before, Lordship, but
Then-
what I say, my friend said that the annex 2 is consequent to the order passed under annex 1.
That may be a fact, that may be a factual mistake on my part. Not, but
I'm not saying that.
that's right.
There is
That-
no appearance.
but that has led to
Let
passing.
us come to annexure 1.
Right.
That is the order under challenge.
Yes.
So whether this order could have been passed.
That is the authority, central government authority.
That's why I'm seeking time, because last occasion I also clarified the same. I wrote a letter, I have not received anything, let's say keep it some other day. I can know what position there, because what my friend is saying that as far as the filing rejoinder is concerned, and last that he has taken time that we'll file the rejoinder in the meanwhile. If you could not file or they are going to file, In the meanwhile, he can file it today also. Yes. In the meanwhile is, you can file it today.
Yes.
In the present writ application is aggrieved by an order dated 12/3/2024 passed by the additional secretary and the revisional authority under section under rule, which rule?
36 months, 36.
Under rule 36
Sub
of
two.
minerals and minerals bracketed other than atomic and hydrocarbon energy minerals bracket close concession rules 2016, mainly on the ground that he has not been given an opportunity to file a rejoinder, to file his comments to the comments in reply to the comments filed by the state,
government.
State.
filed by the state as contemplated under subsection 2, sub-rule 2 of rule 36 of the rules. Full stop. Learn further comments or further comments. Mr. Padhi, learn Deputy Solicitor General for India submits that he has not received instructions despite communication having been made to the authorities in this regard, in this matter. Full stop. List this case on 2 weeks. Full stop. In the meanwhile, the party shall maintain a status quo.
Great.
Item number 3.
Item 3, my lord, where appearing for the, my lord, the appellants, my lord. My lord, our name has not come up in the list, for which, my lord, we have missed it, my lord, let it come next week.
Your
We are
name
the
is
new
not there.
council. No, my lord,
Given behind anything.
we are the new council, my lord. We have filed our VNama on 6/2/2024.
As requested on. When did you file?
6/2/24, my lord.
What is your name?
Kaushik Swain. Kaushik Swain.
This so states that he has filed a fresh wakalatnama on behalf of the appellant in this
Yes,
case.
my lord.
Stop. His name is not, however, reflected in the daily cause list. Stop. As requested, list this matter on when?
My lord, on 1st of May.
2 weeks. 2 weeks. Let name of Mr. Swain be appear in the daily cause list.
Item-
Cause list. Daily cause list.
You are superseded,
I'm for the respondent, my lord.
respondent.
Yes, ma'am. Grateful, my lord.
This is weekly daily or what is it? Daily cause list.
Published.
Item 4.
My lords, I have served the copy
Copy, my lord.
and I will e-file this because, my lords, I will e-file. Hard copy is with me, but I will e-file. I will not file, I will file e-file. I will e-file for my lord's brief.
What was the order?
The affidavit was to be filed, my lord. I have filed that amendment has been carried out. And I have that to that extent, I have filed the affidavit. So I have given copy to petition.
I want 2 weeks time. Give the reply. The short reply will be discussed.
In compliance of this court's order.
15-4.
Huh?
15-4.
15/4.
My lord.
An earlier order also.
The last order is 15-4.
But the main order was 18/7.
22-24.
20.
22-24.
In compliance of this court's order dated to 22/22/2024. An additional affidavit.
My lord, affidavit.
An affidavit has been filed online on behalf of the estate, as submitted by learned AGA. Stop. Learned counsel for the
For petitioners.
petitioners,
For the respondent.
The
what?
respondent.
for the respondents. Seeks adjournment.
I am for the petitioner.
He is for the petitioner in this case.
I am for the petition in this.
So you
Sorry, ma'am. She is for the petition, I am for the opposition.
change
For the-
positions.
For the petitioners. Seeks adjournment to consider this affidavit. So stop as requested, list this matter on 2 weeks.
Item number 5.
May I please, your lordship? Petitioners are villagers of Tikalpada, Kaladi and Palka Gaon of Kandamal. Filed this PIL, they are the villagers. Now they have filed this PIL for not acquiring and construct the bypass road over NH 157 at Fulbani district over the proposed route and to acquire and construct the bypass road in other alternative route, mostly over available cultivable land, which will cause less loss of public properties and minimum expenditure to the public fund. The bypass road of NH 157 starting
What
from.
kind of PIL is this?
Lordship, because if the alternative route,
Are we land
social
acquisition
impact
officers?
is not being properly.
We are engineers. They have to take a policy decision.
They, for that reason.
You want disposal of your representation?
Yes, your
That
lordship.
we will never do.
As your lordship, please.
The petitioners have filed present writ application in the nature of public interest litigation, raising a grievance that the state of Odisha and its officials are not considering the genuine grievance of the petitioners and other villagers of not acquiring their land for constructing a bypass road over proposed route. So, and counsel for the petitioner has argued that in public interest, the authorities ought to have acquired the land of these petitioners for construction of bypass road. So stop. He has also argued that if alternative route is taken, is considered by the opposite parties by acquiring cultivable land, the same will cause less loss.
Less loss and
Less
minimum
loss to the
expenditure of public.
Properties. Stop. Next, in our considered opinion, it's purely an executive function as to which land is more appropriate for being acquired for construction of bypass road. So stop. This writ petition in the nature of public interest litigation is thoroughly misconceived and stands dismissed accordingly.
Item number 6.
May I please, your lordship?
Yes.
My lord, an impugned order dated 23 November 2022 in matter number 110
That
of
is not impugned order, Mr. Counsel.
my lord.
Impugned order means order which you are challenging. Are you challenging that order?
No, my lord.
Why are you saying impugned order?
My lord, sorry, my lord. An order dated 23 November 2022 in matter number 110 of 2019 passed by the Honorable High Court, where the opposite party respondent was directed to pay a sum of rupees 10 lakh to the appellant petitioner within 3 months from the passing of the order.
So you should have filed an execution case.
My lord, the execution
This is a decree. Please come to paragraph 6. Draw the
My-
decree accordingly. you can file an execution case. But the decree has been drawn.
My lord,
Decree has been drawn.
my lord.
Where is that?
In Sambalpur court,
Then this contempt application, how can you maintain this?
my lord, kindly admit the case and issue
Where is the
notice.
question of admission, Mr. Counsel? This order was passed in 2022. And it's a decree. Where is the question of? Did you file any execution case?
No, my lord.
Then the present contempt application has been filed against the respondent alleging disobedience of this court's order dated 23/11/2022, passed in MATA number 110 of 2019. Full stop. Following is the operative portion of the order 6, 7, and 8. Full stop. In response to a query made by this court as to whether any execution case has been filed or not, in terms of the said above noted order of this court, learned counsel for the petitioner has answered in negative. Full stop. Next, in our considered view, no case of deliberate disobedience of the court's order is made out. Full stop. Made out, this application is misconceived and is accordingly dismissed. Yes.
Item number 7.
The 7,
My lord.
you may grant me some time because it has been listed for the first time regarding compliance of lordship's order. I've taken instruction, lordship may grant me some time.
14/9/22, physically handicapped candidate, 2 months time was allowed to give
All
him.
right, he is
Yes, yes.
seeking time
Let him
just
come
to
positive.
have it.
Yes, yes.
Now, as requested on behalf of the contemners, 2 weeks, 3 weeks time is allowed to seek instructions as to whether this court's ordered disobedience of which has been alleged in the present contempt application has been complied with or not.
Item number 8.
May I please, Your Lordship? Challenging the order of the Honorable Single Judge. At the outset, Mr. Mahanti and petitioner submit that although the information sought for the supplied, but the information and serial number has not been supplied. It is his submission that the petitioner had in fact sought for the statement defense he had submitted before the disciplinary authority. But the petitioner was deprived with the application on 21st July 15 filed by him to release some arrears salary. And commission without appreciating the same.
So what is
disposed of
wrong
the
with yours?
appeal. Miller, kindly see. Thereafter, after the order, thereafter he filed the appeal. Kindly see the annexure 7.
Mr. Counsel, please come to the order passed by the learned single judge. What is wrong in it?
In final order.
Huh?
It is the first order. Thereafter, I filed, obeying this order, I filed appeal under annexure 7. Kindly see the page 29.
There's no right to information. No?
Kindly see page 29, Miller. In 5C, see column number 5C, my form.
Mr. Counsel, some information was supplied by the PIO to you.
That is wrong information. I have asked for certain documents, but repeatedly the wrong submission.
So then you could have filed an appeal against that order.
Filed appeal.
Then?
Appeal is under second time after the order. Under annex, kindly see annexure 7.
Yes.
Annexure 7 specific details information required. And I require that office order dated.
Annexure 7 is not your appeal. That is an application.
That is application after the order of the Honorable High Court.
Therefore, appeal will not lie.
Thereafter, this this information has not been supplied. Again, I am filed second case. In second case, Honorable Single Judge directed me to file the 19.2 under 19.2.
What is wrong?
But
with it?
19.2 is the third party information, not first. I am for the first party. Repeatedly, I am asking for my.
Just a minute.
Well, kindly see the 19.2. Where an appeal is preferred against an order made by the Central Public Information Officer of State Public Information, as the case may be under Section 11 disclose third party information.
So then you could have filed appeal under subsection 1.
So I have filed, but he has not been submitted. I again approached. He, Honorable Single Judge said that in 19.2 you may go. Second time, I filed first time. My Honorable Single Judge.
All right. Which order had you challenged before the
Final order, my lord, under 3/1/2020.
Where is that?
In Annexure 9, page 36.
Sir, counsel, which order you had challenged in the writ petition?
Order dated 3/1/2024.
3/1/2024 is the order passed by this court.
This court.
Which order you had challenged in the writ petition before, which was taken up by learned single judge? No, you were seeking a direction.
My lord, my application after the first case, I'm submitting, my lord. After the first case, Honorable Single Judge disposed of my application at the stage of admission.
First case was filed for what?
Filed for the certain documents I required.
Hmm.
The Honorable Single Judge said that filed the appeal. Filed again for the case. I filed on Annexure 7. Kindly see Annexure 7, the copy of the statement submitted by the Sarananda Nai teacher in the 4 similar. Kindly see page 29. That particular document I have been asked since long, my lord. And thereafter, kindly see Annexure 8. He has submitted. On page 31. 3 the information. The department has submitted, but my document which I required, I prayed for. That document has not been submitted to me. Thereafter, I filed second case before the Honorable Single Judge. Honorable Single Judge said, no, this is not maintainable, go to 19.2.
So is this your case that the High Court's order has not been complied with?
First case is not complied. Thereafter, I filed second case.
Let us understand it differently.
Yes, my lord.
You filed an application under the Right to Information Act for certain information.
Yes, my lord.
What happened thereafter?
Thereafter, I filed information. Yes, the information has not been supplied to me. I filed second appeal. That first appeal, that the information has not been supplied to me. I approached before the Honorable Single Judge in first case. The Honorable Single Judge said that you approach again. I approached again.
So that was fresh proceeding.
Fresh proceeding, that was not been supplied. That documents has not been supplied to me. Then I again approached before the Honorable Single Judge. Second case.
Why did you go to Honorable Single Judge? Why didn't you go to the first appellate authority?
I have gone, but he has not supplied. He has supplied some document. Kindly see, he has supplied some documents which is not relevant to me.
Therefore, you could have challenged that order before the appellate authority, first appellate authority. It's a fresh proceeding.
I approached before the Honorable Single Judge that order has not been carried out.
Single Judge is not the appellate authority. The appellant in the present intra-court appeal has put to challenge an order dated 3/1/2024 passed by a learned single judge of this court in WPC number 40301 of 2023. Stop. Next. From the pleadings on record and submissions advanced on behalf of the on behalf of the appellant, it transpires that the appellant had made an application before the public information officer for supply of certain information. Stop. As the said information was not supplied, he had preferred first appeal, preferred an appeal before the appellate authority. Stop. He had to approach the second appellate authority, as the first appellate authority also did not take any step, that had also not passed any order. Stop. The petitioner had thereafter approached this court by filing a writ petition giving rise to WPC number 21240 of 2023. Stop. This court, by an order dated 12/7/2023, disposed of the said writ application, giving liberty to the petitioner, giving an observation that if the petitioner made a fresh application for supply of the documents, the same shall be considered in accordance with law. Stop. It is further the case of the appellant that pursuant to the said observation made by this court, the appellant had again appellant had made a fresh application for supply of the information, but the PIO supplied such documents, public information, which were not sought for by the petitioner. Stop. Next, by the appellant. Single judge noted that the appellant had remedy under section 19(2) of the Right to Information Act by filing a first appeal. Stop. With the said observation, the learned single judge disposed of the writ petition by the impugned order. Stop. Next, learned counsel appearing on behalf of the appellant has submitted that section 19(2) of the Right to Information Act has RTI Act has no application in the present facts and circumstances, as the appellant was not seeking any information regarding third party, but rather the information which he had sought related to the appellant himself. Stop. Next. Then 19(1) will apply?
I have applied 19(1).
When did you apply 19(1)? 19(1) you had earlier applied.
Earlier applied.
Learned counsel for the petitioner appellant has, however, submitted that an appeal would lie under section 19(1) of the Right to Information Act, of the RTI Act, by filing first appeal instead of section 19(2) thereof. Stop. Next. In the facts and circumstances, from the relief sought in the writ petition, it appears that petitioner sought for a direction from this court to direct the public information officer to supply information as per the observation made by this court by order dated 12/7/2023, passed in WPC number 21240 of 2023. Also, such such relief could not have been entertained by the learned single judge in the writ proceeding, was not required to be entertained by the learned single judge. Also, if according to the appellant, there was any violation of the court's order dated 12/7/2023, he could have preferred a contempt application. First off, there was no question of successive writs being used by this court, being issued by this court. First off. Secondly, if the submission advanced on behalf of the appellant as noted above is accepted, he has right of appeal. He had right of appeal under section 19(1) of the RTI Act instead of section 19(2). Stop. Next, in such view of the matter, this application and this appeal is inter-court appeal is disposed of with an observation that the petitioner appellant may invoke section 19(1) of the RTI Act by filing a first appeal. The writ petition, the writ appeal stands disposed of accordingly. Yes.
Item number 9.
Actual direction, I have supplied the English translation of annexure 3, my lord.
Yes.
That is advertisement, my lord.
Yes. Where is the translation?
My lord,
Where is the translation?
I have already supplied file, my lord. On 19/4.
Yes. Got it. Madam.
The petitioners, my lord, case of the petitioners, my lord. They have applied for the livestock inspector, for the post of livestock inspector, as per the advertisement under annexure 3, my lord. The petitioners are the Go Mitra, and they have acquired
Which post?
for livestock inspector, my lord. The
Livestock inspector
inspectors, my lord.
is animal husbandry officer.
My lord. The minimum educational qualification required, my lord, according that the applicant should have a +2 as well as the vocational training certificate, my lord. The petitioner are the +2 arts and commerce students, and they have also acquired the +2 vocational certificate, my lord. Accordingly, they applied, and their merit list they are selected. But in the selection list, their name does not find place on the ground that on the objection of some others, my lord, because the petitioners and others, they have acquired the +2 vocational certificate by practicing fraud. That is, my lord, by obtaining duplicate SLC on the ground that their original SLC certificate has been damaged by the white ants. Very broad. For that reason, it was held that the honorable single judge held that because they have practiced fraud in obtaining the vocational certificate, that is why their candidature should not be rightly has been rejected. I may submit for the honorable single judge, honorable order, it has been passed in 2 writ application, Lord. In composite order has been passed at annexure 10 at page 102.
Yes.
Order of the honorable single judge, Lord. Page 102, it starts from page 102. at 104, your lordship will find the orders have been passed in WPC number 16,810 by 2016 and WPC number 18,225 of 2023. The present appellants, two appellants, were the petitioners number 4 and 5 in the read petition number 18,225 of 2023. Your lordship, while considering the applications of the both the petitioners of the both the read application, your lordship, the honorable single judge had carried on to the facts and circumstances of the WPC number 16,810 of 2026. It was an 16 minutes. Only elaborately they have honorable singular had discussed about the case of the both the petitioners and opposite party in WPC number 16,810 of 2026. But on lastly, at page 124, only mentioning that the petitioners, the present petitioners were the appellants, were the petitioner in the 4 and 5 of WPC number 18,2026. They are also in the same footing and they have also practiced fraud by obtaining duplicate SLC and got admitted in the +2 vocational test. Vocational training ground. On that ground, there that is why I have sought for the information from my clients mirror, whether they have obtained the SLC on the ground of damage of white hands or by seeking permission to get the order for to get admission of +2 vocational training ground. That
Be
they have
careful.
said, for they have said, but they
Be careful. You have invoked writ jurisdiction of the High Court.
my lord.
Your certificates were damaged by white hands. Plea which you are taking may not be accepted. The case of fraud.
That is for that reason, honorable single judge holds that the fraud vitiates everything
What is wrong?
and
And one single judge has taken into account all the facts discussed.
all the facts.
everything. No independent.
In particular in my appellant's case, Lord, they could not remember whether they have obtained the certificate by on the region for white hands, damage of white hands, or by seeking permission that we will
And
take
if
admission.
their
That
memory is so short,
yes,
if their memory is so poor, then they should not be.
that they could not
They should not have been
answer.
otherwise considered.
No.
Because it's a case of some mental case. If someone does not remember whether he had or received the certificate, obtained the certificate, or why did he apply again?
But by that time there is no bar for the subsequently 2015 the bar came that they cannot obtain the both the qualification. Prior to that, it was admissible. But whether they have obtained the SLC
qualification simultaneously.
simultaneously. For that reason, they said that is fraud has been committed and it vitiates everything.
That vitiates everything.
That is the sole reason.
The present inter-court appeal. The appellant has questioned the legality of an order dated 2/2/2024, 21 to 2024, passed by a single judge of this court, whereby the writ petition filed by the writ petition. You are the
I am the petitioners number 4 and 5 in writ petition number 18,225 or
writ petition filed by the appellants. Bracketed WPC number
18,225 of 2023.
18225 of 2023 has been dismissed. First off, the appellants were petitioners number 4 and 5 in the said WPC number 18225 of 2023. So next, the controversy related to recruitment for the post of which post?
Livestock inspector.
Livestock inspector pursuant to an advertisement issued by the district chief veterinary officer, Jagat Singhpur district. Correct?
Madam.
First off, the petitioners, the appellants were shortlisted after following the recruitment process. First off, apparently, based on certain allegations made by the participants in the selection process, selection process, the certificates obtained by them, by the appellants, were scrutinized by the authorities. First off, the same were found to be found to have been fraudulently obtained. First off, and single judge after having examined the pleadings / counter pleadings on record, concluded in paragraph 8.1 as under 8.1 and 8.2 as under. Stop. Then counsel appearing on behalf of the appellants has not disputed the finding of fact recorded by the learned single judge as noted above. Stop. He has, however, submitted that the appellants did not remember as to whether they had obtained physically obtained the certificates from the council.
My lord, SLC, school living certificate that is.
From
Council of Higher Secondary Education.
from the Council of Higher Secondary Education of having passed +2 vocational certificate for certificates or the same had been destroyed by white ants. Full stop. He has submitted that the second course certificate in such circumstance ought not to have been rejected. Stop. Next. There being no dispute about the fact as concluded by learned single judge that the appellants had obtained second higher secondary course certificate fraudulently.
Duplicate higher secondary certificate.
Huh?
Duplicate certificate.
Duplicate. So second duplicate plus 2 higher secondary course fraudulently, comma, we do not find any reason to interfere with the impugned judgment of the learned single judge. We do not find any merit in this appeal, which is accordingly dismissed.
Item number 10.
Back. This case, my lord, the petitioners questioning the amended rule of the Odisha Adarsh Vidyalaya Sanghatan under
Which rule?
Annexure 6.
Annexure?
Annexure 6 is 106. The provision not incorporating the previous provision by virtue of which we have been appointed, but eliminating that now our promotional avenue has been taken away. Now the fact is, my lord, this Adarsh Vidyalaya Sanghatan by the state of Odisha was established because to give impart education in the CBSE pattern of examination. In the year 2015, a recruitment rule was framed, page 35, the first rule in 2015. There was a provision. Initial entry into the post is trained graduate teacher, that is called TGT. And there was a provision for promotion to the post of PGT, that is postgraduate teacher. Only with a condition on completion of 6 years of service. If you have the post graduation in the concerned subject, then you can be considered for promotion. That was the avenue. 4 categories there were initially, that my lord will find it at page 48. There were provision.
No, on what ground you are challenging?
Yes, that is, this is the ground, my lord. Initially,
That cannot be ground.
no, these are the in the rule, earlier rule.
When you are challenging virus of any statutory
My lord.
provision, you should say it violates.
Yet it is
any
violated by
article.
Article 14. That I will say, my lord. But to fact, I have to, otherwise I cannot convince, my lord. So initially, there was a provision. When establishment was there, the rule has come. Thereafter, we have applied and got a post of TGT, graduate teacher, with the avenue in the rule itself that yes, we have a chance of promotion to the post of PGT. In 4 categories we belongs to, that is TGT Social Studies, that is a TGT post, base level post. But when it will come down to PGT, postgraduate teacher, that will be for history, geography, economics, political science, sociology. Similarly, my lord, TGT Hindi, PGT Hindi, PGT Sanskrit, PGT Sanskrit, PGT Sanskrit, all these provisions were there. We have applied for. Subsequently, this rule was further amended in 2019. The same thing retained. So in the meantime, because we joined in 2015, 16, so we have completed 6 year service and we are otherwise eligible for consideration for promotion as per the rule. But now in 2014, now what the authorities 2024, they have amended that rule and brought in repealed all these old rules and brought in a new rules, eliminating these 4 group of employees to get an opportunity of promotion. Other categories they retain, but so far this social studies, they have confined only to commerce and economics. This geography, history, because the petitioners belongs to that, the post graduation in that particular subject, and they're continuing in TGT. Now the avenue is taken away. Other groups that have been retained. So far ODI is concerned, that is also taken away. And so far the English is concerned, what they have done, only if you have entered into the base level service as a TGT English, you can only get a promotion to the TGT English. But if you have been joined as a TGT Social Studies, because and I got a PG qualification later on in English. Now I cannot go to that English. The petition number 3 is that category. Now by virtue of this, my lord, we all are continuing in government or other institution because this is a better avenue. We have resigned and joined it here because on the same government. Now by virtue of the change rule, my lord, now our promotional avenue has been seized for all time to come. And the other group of persons, those who are recruited along with us, fortunately they belongs to that category or economics or social commerce. Now they have the avenue. So we have been discounted now. That is why I'm on that ground, I am challenging this rule, my lord. I'll take
Fine.
well,
6 weeks time is allowed for the state opposite parties to file counter affidavit. Discuss matter on 6 weeks.
Item 11.
This petition in the nature of, my lord, public interest litigation, your lordship. The petitioner, for the interest of people of village, they will file this writ against the illegal encroachment of village road, your lordship.
The ring road you can file.
My lord.
That decision we have rendered.
Yes.
In case of Panda.
Trinath Panda, my lord.
Trinath Panda, you can file. In terms of Trinath.
Item 12.
May I please,
Trinath
Your
Panda has not come in ILR. Trinath Panda has not yet been reported.
It has been reported. I haven't received from the.
Put in ILR, I think, Lord. It's ILR, it has been.
Must be ready with that citation so
No,
that.
no, we have got the copy. I have got the copy.
We have got the copy of the lordship's order.
No, that is there, but
I will give the rate number.
reported.
I'll find out where it has been reported, we'll find it. Because there was
If it is
the
there, please supply.
It must have been already reported.
May I please, Your Lordship?
Yes, sir.
12.
The petitioners were identified as landless persons, and accordingly they were identified to be allotted lands under the ERRP scheme of the central government. The petitioners were given a tract of land on which they were to have a cashew plantation. Now, once the cashew plantation were tended by the petitioners and they thrived, other people, they started disturbing in the possession, and the state government started a series of encroachment cases against the petitioner, even though they were allottees of the land. At that point in time, the petitioner came up before your lordships in a writ petition, and your lordships were seized of that matter for quite some time. And ultimately, on 3rd of March 2022, page 16, an order was passed.
Yes.
Your lordship may take paragraph 4 at page 16. The issue concerns 6 petitioners who claim to have cultivated cashew plantation pursuant to a rehabilitation scheme of the Government of India implemented by the Government of Orissa for over 30 years now. At one stage, the Tehsildar Baliguda, District Jagatsinghpur, filed an affidavit on 15th of September, where in para 5 it was stated as under that in the case in hand, 52 acres of land was identified in village Keupada, Brahmanadiye and Tentuli Bellary. The Soil Conservation Department of the state government has undertaken the Kaju plantation on these lands. But unfortunately, the land was recorded as Gramya Jungle and not wasteland. But for the purpose of Kaju plantation, the entire expenses were borne by the Soil Conservation Department. When the plants became fit for production, then patch of 2 acres each was allotted in favor of 26 beneficiaries, including the present petitioners, and the land was distributed on 15/2/1986 on the recommendation of the village committee in presence of Assistant Soil Conservation Officer Jagatsinghpur and other officials under Annexure 2. A close reading of Annexure 2 goes to show as follows. From today, the beneficiaries will enjoy Phalo Bhogo Satyo by taking care of their respective cashew plants the plantations will be taken care of till the aid available from the government. The petitioners were conferred with Dafayati right, but not ownership right. Therefore, the claim of the petitioners, the land be settled with them by the Tehsildar, is not tenable in law, and as such, the writ application is misconceived and based on misconception and misreading of annexures 1 and 2. Subsequently, an affidavit was filed by the Tehsildar on 15th March 2019, wherein, this time in para 5, it is stated the petitioners were conferred with Dafayati right but not ownership right, and that the land being an objectional one, encroachment proceedings were initiated against the present petitioners and fine and penalty have been collected from them. An interim order was passed in the present petition way back on 24th March 2003, directing the status quo to be maintained. As a result, for nearly 35 years now, the petitioners have been on the land, cultivating it and enjoying the fruits of such cultivation. In the considered view of this court, the state government should seriously consider whether a fresh policy or scheme needs to be formulated, recognizing the possession of the petitioners over the land in question as well for well over 3 decades. A direction is issued to the Secretary of the Department of Agriculture to place on record the present stand of the state government, State of Orissa, in this regard in the form of an affidavit to be filed within 1 week prior to the next date. Thereafter, my lords, the next order is at page 19. On that date, the court passed this following order. The court has perused the affidavit dated 21st June, filed by the Special Secretary to Government of Orissa Agriculture and Farmers Empowerment Department, which states inter alia that the scheme floated in 1980 was only for a period of 5 years and that due to efflux of time, the petitioner's right to enjoy the fruits has also ceased. It's further stated that there is no proposal for any fresh policy in this regard. The court finds the affidavit does not address the fact, as noted in the court's order dated 3rd March 22, which I just placed, my lord, that the petitioners in the present case have been cultivating the land in question for nearly 4 decades. It is only after 2 decades of their cultivation when a notice is issued to them seeking to evict them that they approach this court. The status quo pursuant to the interim order passed by this court has continued for 2 more decades. Thereafter, para 4. It is not clear from the affidavit filed whether the government requires the land in question for any specific public purpose. If in fact, there is no such supervening public purpose for which the land is required, that the government should seriously consider whether in all such cases where the persons have been cultivating the land for well over 3 decades, a scheme should be formulated which would be beneficial both to the persons undertaking such cultivation as well as the government. At this stage, Mr. Mahanti states that the government will take a policy decision which would take at least 6 months. In that view of the matter, while directing that the government should take a policy decision on the issue in light of the orders passed by the court on the 3rd March 22 and today, the court further directs that till such time the policy decision is taken, the status quo as ordered by the court earlier vis-a-vis the petitioners will continue. The policy decision should be taken within a period of 6 months from today and in any event not later than 1st February 2023. They did not do the policy and they came up before your lordships with an application for extension of time. That extension was granted, my lords, on the 31st of March 2023, wherein 6 months' time was further granted, which your lordships will get at page 22. Now, despite all these orders, my lords, we are still not aware of what policy the government has taken pursuant to your lordship's order. What has happened in the meantime is some people who are basically amongst the stand mafia of that area, they made an application to this honorable court wherein no notice was issued to me saying that we are encroachers in that respect of the land. And this honorable court was pleased to make an order which your lordships will get at page 19, my lords. No, sorry, my lords, not page 23, my lords. Page 23. Your lordships will see in paragraph 2
that no notice be issued to opposite party number 5 as the matter is disposed of the stage of admission. I was opposite party number 5. Instant writ petition is filed by the petitioners for a direction to opposite party, in particular opposite party number 4, to consider the representation and Annexure 3 and to take necessary action to evict the alleged encroacher, namely opposite party number 5, on the grounds stated therein. Learned counsel for the petitioner submits that despite representation and Annexure 3, no action has been taken against the opposite party number 5, and hence a direction is required to be issued in that regard. Thereafter, this court, para 7, in the result, the writ petition stands disposed of with a direction to opposite party number 4 to consider and examine Annexure 3 and to take appropriate legal action after providing due opportunity of hearing to the petitioner as well as opposite party number 5 to complete the entire exercise within a period of 6 weeks from the date of receipt of copy of this order, and in case encroachment is established, to ensure its removal within the above stipulated period. Obviously, the proceedings before this honorable court, the orders passed by this honorable court were not brought to the notice in the other writ petition. Now, thereafter, the Tehsildar at page 25 issued a notice to me saying that I will demarcate the land. He has carried out the demarcation. Now, I wanted to know what demarcation he has carried out, and I applied for a certified copy of the.
This is PIL.
No. It's my land. I'm seeking protection of my land and for settlement of the land in my favor.
No, why the petition is it's a division bench roster assignment.
My lord, it's come before your lordships in all probability because the previous writ petition was disposed of by the division bench.
Oh, one could have filed a contempt.
I could have filed a contempt, but my grievance is not only confined to they're not making the policy. My grievance is further that you have carried out a demarcation, whatever be that case. Now provide me with a report which is not being provided. I have applied for it. Your lordship sees way back. In January 2024, I made the application.
How the staff reporter has pointed out that this is a division bench matter.
May I come in, my lords? The earlier matter was a PIL, my lord.
Therefore, the earlier matter was PIL, therefore that was before division bench.
Yes, my lord. Yes.
There is no more a PIL.
No more a PIL. Yes, my lord. That is.
No, my lord.
It should not have.
My statement is not correct there. The earlier matter was under the provisions of the Orissa Government Land Settlement Act. For settlement of the land in my favor, that was the prayer which I had made. It was not a PIL. When 6 persons, 6 allottees were before your lordships. Now, my lords, this is one of them. One amongst those 6. In fact, that person is dead, is legal as there before your lordship. And most probably it came up before the bench of the Honorable Chief Justice at that point of time because it was an old matter. It was a 2002 matter which was being taken up in 2023, 2021.
In fact, we have to take instruction, my lord. I think there has been a guideline formulated on 5th of June 2023. I have come across a letter of but that I will need to file an affidavit. Yes.
Serious matter. If we find that despite this,
they have taken some guidelines as how to.
You see,
settle the lands in this.
5th of June
But
may not be there because
5th of June 2023, there is some guideline that has been issued. Giving,
File your
giving exhaustive steps as to how to allocate the land or how to settle the land in these favors. So I'll file an affidavit, but his prayer is for demarcation and for
no, not for demarcation. Demarcation has already been carried out.
demarcation report to be provided.
Mr. Mukherjee,
Yes.
As far as
in
only
the title,
Yes.
in the cost title, you have mentioned about policy
Policy,
decision.
only policy, but if you are
Please,
sees
please.
this,
But when we read this,
Prayer, my lord.
prayer, second prayer is the demarcation report to be provided.
yes.
So this gets confusion whether it is division.
And the first prayer is
and
also
your
settlement of land.
Category number. You have consciously put maybe for division,
My-
listing
my-
it before the,
My lord, my
Division.
concern is to get the land
and your
settled.
prayer is not to enforce the policy.
No, yes.
As you have stated in the cost title. While you are.
I have made both the
pressing-
prayers, my lord.
You know,
No, prayer is for
Settle the land, settle the
Yes.
land in.
that is not
pursuant to the
relatable to any policy.
That is the direction made by your lordships. To formulate a scheme by which the land can be settled, so that since
All right,
they-
we'll see. File your affidavit.
I'll file.
In this manner, applying to OP number 1, Government of India. So the scheme is the central government scheme, on the basis of which all these things have happened. So I am applying to.
Document of rights. Was put to a double.
that pending disposal, my position may not be interfered with. Your lordships have all throughout protected me, so that protection may further be extended.
Let me take instruction first in this case, my lord, because
2
some,
weeks, let it come after 2 weeks.
Oh.
2 weeks time is allowed for the estate to file counter affidavit. Full stop. An appearance slip has been filed on behalf of the Union of India, bracketed OP number 1, which is taken on record. Full stop. Does this written within first 5 cases on first sentence क्या है? Put this case on 2 weeks within first 5 cases. Stop. Till then, the parties shall maintain a status quo.
Public.
2 weeks.
no, since my lord, I was submitting, my lord, since there's already a guideline, so I am not aware what steps the government has taken. my lord.
Therefore, because you are not aware, 1 and 2, when was the copy of the writ petition served upon you?
5/4/2024, it was filed.
So it must have been a copy must have been served upon
Advance
you.
copy was served.
5th April.
So since it relates to
Yes, I'll take instruction.
Item number 13.
you shall have liberty to apply for vacating the order of stay. There is no
I can do that.
My lord, I am challenging inaction of the OP number 2, my lord. My lord, I am challenging inaction of the OP number 2, my lord, Collector Bhadrak, who is not disposing our grievances under Annexure 2, my lord.
Same, my lord, government land encroachment. Government land
Encroachment.
My lord, those persons who have enough for landed property, they are encroaching the government land.
You can apply that judgment of this court. 2024 Volume 1 ILR CUT 396. Like there is a decision that when there is any encroachment on a government land, how one can approach to which authority and how such grievances are to be redressed. So that's there in the decision.
Item 14.
My lord, the Annexure 2 is pending before the OP number 2, my lord.
Item 14.
Mr. Two is pending before OP number two, my lord.
Again,
The same.
No, my lord.
Encroachment.
No, my lord. This is that government is trying to construct some development work over the Gochar land. Though there is enough landed property existing, but some development work is going on over Gochar land. That's why the persons of the village made a representation to the collector, which is pending. The lordship may direct to.
either we will allow your repetition or we will dismiss it. Presentation. So let us see what is the merit.
Government have
This deserves to be dismissed with cost. Come to paragraph 3. Read it loudly.
petitioner is leading person and social activist as well as the leader of local community.
So you are leading person, social activist, and leader of local community. And then you are facing. Then read it.
Facing a lot of difficulties on
A and B have been issued to them for eviction, and it will require some time to evict them from the land.
So that is not the direction. It was not the direction to evict them. What is the order?
If your lordship look at order at page 2 of the order of the Honorable Court, Milords. Direction is we direct the Tahsildar Remuna, the OP number 4, to dispose of the representation dated 17/11/2022 within a period of 4 months from the date when a copy of this order will be supplied to him after due inquiry and on affording reasonable operative
Yes,
hearing.
that your representation has been disposed of. They are taking steps. There was no direction to evict. There was direction to consider your representation and proceed. They have proceeded. Public interest litigation. A writ petition in the nature of public interest litigation was filed before this court by the petitioners, giving rise to WPC number 16872.
They have not committed to us, my lord.
Huh?
They have not committed to us. They are not committed to us.
No, we have not filed an affidavit. I've said that.
So do it by within a week.
That affidavit I can give it now.
So the learned AGA representing the state of Odisha has submitted that this court's order dated 3/7/2023 has been complied with. Stop. He intends to file an affidavit in this regard. Stop. Test this matter on 1 week. Let the affidavit be filed in the meanwhile.
Item number 16.
This item number 16, pursuant to lordship direction, hearing by the Tahsildar is concluded and it is posted for pronouncing the order on 24. I pray lordship may call it on 29 so that I can file the order of this honorable.
20 as requested on behalf of the contenders to report full compliance of this court's order, a violation of which has been alleged in the present contempt application. List this matter on 29th.
Item 17.
Oblige your lordship. Non-compliance with the order dated 7/7/2023. I have quoted in page number 3, your lordship. Item 17, your lordship. Page number 23, my lord, contempt petition. I have quoted the order 7/7/23 is order.
We have not annexed the order.
Order, I have already quoted my petition, my lord. It's page number 3, your lordship. 7/7/23 order declared. Page number 3 and 4, your lordship. Direction is that Collector Kotak to carry out the inquiry whether the Gochor land or any part of thereof situated on the village of Notkai under Nishchindakari block has been encroached or any construction has been made on the Gochor land and or whether there are allotments without following the de-reservation proceeding. On the outcome of the aforesaid inquiry, due to action shall be taken by the collector for protection of Gochor land, the Collector Kotak shall furnish a copy of the said inquiry report to the petitioner by registered post in the address given in the petition. Till that they have not complied this order or not taking any steps or not furnish any copy.
Yes, file your
Yes, I'll file my affidavit. Not
4 weeks time is allowed for the
They will oblige to us.
for the contenders. 4 weeks time is allowed to learn AGA to seek instructions and file affidavit stating as to whether the court's order dated 7/7/2023 passed in WPC number 20917 of 2023 has been complied with or not.
Item number 18.
May it please. Your Lordship, the petitioners had approached initially the Labour Court for computation of their area salaries. The Labour Court passed an order in favor of the petitioners. That order was challenged by the opposite parties before your Lordship in WPC number 8090 of 2015. And that stood disposed of, confirming the order of the London Labour Court, and 3 months time was allowed for compliance of that order of the Labour Court. That was not done, and the petitioners filed a contempt, that is CNTC number 7955 of 2023, wherein your Lordships were pleased to allow for the 4 weeks time to comply the order. In the meantime, the opposite parties had sought for time to comply the order in the disposed of writ petition. That was also allowed on 16th January, allowing 4 weeks time. Now, virtually, your Lordship, the initial order being 11/4/23, 1 year has passed in the meantime and compliance has not been made.
Yes.
It's
a gross case of contempt.
Notice has to go over a weekend. It says federation notes.
We should
It's
notice.
been-
We should notice. Because it's 1 week. 6 weeks.
Second matter also same. Your Lordship.
Same.
Different set of petitioners.
For orders item number 19.
May I pray for Lordship? I am for the petitioner, my lord.
Your matter was heard.
2 times sad,
So it will come for judgment a day after.
my lord. Okay.
Item number 20.
My lord. My lord, the appellant has made an application for condonation of delay of 78 days, my lord. And on dated 7/8/2023, your lordship, this honorable court has issued the notice to the opposite party.
Yes, any objection?
No, my lord.
IA number. IA. 760
Yes, my lord.
or
760.
761.
760.
No, 760. Huh?
760. Item 20.
Any condonation?
Limitation. 760 of 2020.
Yes,
760. IA number 760 of 2020. This application has been filed for condonation or delay of 78 days in filing the present court appeal sought upon notice. Learned counsel for the respondent has appeared from after having heard submissions made on behalf of the parties and considered the explanation given in the application seeking condonation of delay. We are satisfied that a case is made out for condoning the delay. So this application is accordingly allowed. The delay stands condoned.
My lord,
List
another
this
connected matter.
Is the main matter, list the matter under appropriate heading.
My lord, another connected matter that may be tagged, my lord. Another connected matter is there.
Along
That is WA 373 of 20.
Along with WA number?
373. 373.
So that is not barred by limitation.
Similar. No. That, but that matter has not come. I have filed the condonation of delay also in that.
Then how can this be? In this case, your delay has been condoned. When that matter is taken up, we will see. Yes.
Item number 21. May I please? Item 21 on last occasion, your lordship has heard that matter that industrial 25 FA. Lordship has heard that matter. Perhaps this is for orders.
One day.
Yes, ma'am. Yes, ma'am.
1 day delay.
1 day delay. That I have relied one judgment, my lord. That's
My lordship, I am in item number 21.
Yes.
As far as judgment led by my friend, I have to say that in 35, para number 35.
no delay.
No delay.
No delay.
No, not
delay
about delay.
has been condoned.
No, not delay about.
Please wait. Please wait.
My lordship.
List is heard so and so. Is this matter for judgment on? Monday. Monday.
My lords. Yes.
एक और judgment है वहाँ पे.
Item number 22.
My lord, may kindly turn to the IE filed by the respondent. That is IE 2094 of 24.
Item number 22.
My lord, sir, 2094 of 24. May I take my lord to the
IA number?
2094 of 24, my lord.
Filed by me. Filed by the respondent.
Is there.
To that IA, an order has been annexed, my lord, at annexure B. Sorry, my lord, I'm extremely sorry. That is IA 2093. I'm sorry. I'm so sorry.
2094 of the party.
My lord, 2093 of 24.
Filed by the respondent.
You filed 2094.
2094, due to application was filed. I filed two
Both are filed by the respondent. My lord, may kindly see 2093 of 24. To that IA, annexure B, at page 9 to that IA. My lord, sir.
Annexure B.
My lord.
Yes.
My lord, we'll see that we have, in terms of the seniority, we have regularized these persons. The only problem, my lord, may turn to the next page. Terms and conditions, my lords. Clause 2. The work charge employees involved in court cases should not be relieved to join under regular wages establishment. I was on the last date, my lord, I was submitting to this honorable court that I had called the departmental officers for discussion. They will be allowed within next 2 days, ma'am. 2 respondents are here. They will be allowed. Because there it is in terms of seniority they are getting. The order under challenge, if they succeed, they will get it from 99. My lord, may I record my submission? They will be allowed within this week.
But he retired on 30th this month. Any day, anyway, within 2 days we may pass. Date of return 30 of this month.
What is the age?
Yes,
60.
59.
Then clause 3.
That will not come on the way. That will not come on the way because we are regularizing.
It's clause 3.
Yes, despite this 2 and 3, you will allow. Because we cannot, it is 60 years or 59 years, that way an embargo should not be kept. That I have already talked.
They have to ignore this clause 3. This clause 3, they have to.
No, they are not 60 years. They are not above 60.
They are 60 years of age. They will be 60 on 30th.
On 30th.
So you are not still 60.
59 plus.
59 plus, you are 59 plus, you have not completed 60.
34.
34. 34 there is time.
And our 9 days left.
Another 9 days.
Another 9 days.
Only 9.
All right.
Yes. We'll allow.
Serial number 15 and 17. That orders serial number 15 and 17. 2 respondents.
2 respondents.
Yes. Serial number 15 and 7.
Mr. We are not disposing it off.
No, ma'am.
We will take up the matter on, say, 29th. And before 29th, you may.
I'll report compliance to this one.
This also you should not, this withdrawal of court cases, you should not insist upon.
That's what I have conveyed, ma'am.
Yes.
That we should not have kept such a.
Mr. Anishal and AGA appearing for the State of Odisha / appellants has drawn the court's attention to an order issued on 15/3/2024 by the Office of Engineer-in-Chief, Water Resources Odisha, Bhubaneswar, whereby the work charged employees, including the respondents, are sought to be brought to a regular wages establishment, subject to certain conditions, including condition number 2, which reads thus: Annexure B, page 9 पे, IA number 209. Stop. Mr. Mishra has submitted that clause number 2 as mentioned, submitted based on instructions which he has received, that clause number 2 shall not be invoked. Clause 2 of the conditions shall not be invoked, and the respondents shall be allowed to join under regular bracketed wages establishment within a week.
Madam.
Stop. List this matter on 29th.
One thing, respond number 490 and 525 maybe. 490 and 525 respondent number in the read of it.
400.
490 and 525.
490
and 525 in the read of it.
525. There's so many respondents.
935. They all came jointly, filed one case, and this honorable court has directed to the. Now that we are regularizing in terms of their seniority, I don't have a grievance, and they are accepting it. No problem.
Yes.
Obliged.
Item 23.
The 6 days delay is there. 6 days delay is shown, my lord, in filing of
He will
the,
oppose.
my lord.
He will not oppose.
But in fact, there is no delay. In fact, the period of certified copy obtained is not taken into consideration whenever a delay is taken care of.
IA number 2001.
My lord.
Stop. This application seeking condonation of 4 days delay.
6 days.
6 days delay in filing the present intra-court appeal is allowed. Stop. The delay stands condoned. Yes. List this matter under appropriate heading. Will come for admission.
Can it be taken up today for admission? Can it be taken for today for admission?
Today? Is it so urgent?
No, there is no urgency.
Then let it come.
On next
As
week,
a fresh matter, it will come as a fresh matter.
next week Monday, you know.
We don't know. Come on. It will be list.
Date may be fixed. May I pray, my lord, a date may be fixed.
Appropriate heading as a fresh matter.
Item 24.
May I please, your lord? The officers pointed out that there is 3 days delay, my lord. But actually the appeal was presented on the 30th day, so there is no delay. I have filed an IA. It is 2039 of 2024 for condonation of 3 days.
Allow some more, 3 days. ka allow.
Item 26. 25. Sorry, 25. Sorry. 25.
There is a delay, my lord.
How much? 323 days.
Your lordship may see the impugned order is at page 46. My.
No, what is your explanation for delay?
That I am coming, why I am showing my lords that impugned order. Your lordship, for a moment, your lordship may see, because relying one.
Oh, we will see, we'll see.
My, sorry,
Which order?
page 48, my lord. Your lordship may see paragraph 4.
Yes.
Well, relying that order passed in Mukunda Deori versus State of Odisha, this writ petition was allowed. And that was also challenged in WA number 1609 of 2022. In the meantime, that has been dismissed on the ground of delay.
Mukund Dubey.
Devuri, my lord.
Mukund Dubey has also been dismissed.
On the ground of limitation. So that time I want to show my lords, because
Delay, you have to take steps against the hiring officials.
hearing official, we should take steps. My lord, now that delay period is somehow, your lordship, since some writ of list, now it is within 100 days. We are trying to file with, in some cases that
In the present intra-court appeal, the state of Orissa has put to challenge an order dated 29/8/2022 passed in WPC bracketed OAC number 1259 of 2017, passed by a learned single judge of this court. Stop. The said order has been, the impugned order has been passed after having noticed the fact that the case of the respondent was squarely covered by a decision of this court in case of Mukunda Deori versus State of Odisha, WPC bracketed OAC number 623 of 2018, disposed of on 9/12/2021. Stop. Next, this appeal is barred by limitation. Stop. There is delay of 323 days in preferring the present appeal. Stop. It has been stated at the bar that an appeal was preferred against the decision in case of Mukunda Deori bracketed Supra, intra-court appeal, which has already been dismissed on the ground of limitation.
well, on 13/11/2023.
On
13/11/2023.
30/11/2023.
30 or 13?
13, well, 13.
13/11.
And WA number 1609 of 2022.
And
WA number 1609 of 2022.
On perusal of this application, IE number, IE number 54396. This is your case, yeah.
5437.
5437 limitation.
IE number 5437. On perusal of the explanation given in this application for condonation or delay, we are not satisfied that the appellants have been able to duly explain the delay. Stop. This application is accordingly dismissed. Consequently, the WA number so and so stands dismissed. All the
Item number
all
26.
interlocutory applications.
26,
stand disposed.
sorry, 26 and 27, same. Dealing that Mukunda Deuri case.
Delay.
Yes, all these cases delayed.
323.
So 1-2 days. So all the cases 300 days delay.
More than 300 days. 26, 27.
Other both cases, 320.
On both the
More
cases
than
to 323 days.
That I'm saying.
Both the cases 323.
Item 28.
28 minutes, there is no delay.
1 day delay is shown.
My lord,
1 day delay is shown by the, yes, sir.
15/8 was the order, and we have filed on 16/9.
1 day. 30 days. 1 day.
But since you have filed, no, you have not filed any application.
Under impression there is no delay.
I will have to file, man.
You have to file. But we can condone even without application. Is there?
1 day delay?
Huh?
In no case.
The stamp reporter has pointed out 1 day delay in 1 day's delay in filing the present intra-court appeal. So, in the interest of justice, the said delay stands condoned. This appeal under appropriate heading as a fresh case. No, Monday.
Item number 29.
In 29, there is some days delay, my lord. I have given that explanation. My lord, your lordship may consider my explanation in my.
Where is that? Which IA?
IML 418 of 2024, my lord.
200 some days delay.
I have explained, my lord.
We are issuing notice.
I have given the explanation, your lordship may see. My lord.
No, other side will have to be heard. No.
Yes, my lord, that notice to go. That
Notice.
29
29,
explanation, 250 days delay.
that we have received the order in late. I have given that explanation, your lordship, for my lord's consideration. In paragraph. Your lordship, paragraph 2, the order passed on 21/4/2023 we received on 28/10/2023.
Was not aware.
No, well, we are not ours. We have received that order on 28/10, so there is a 180 days in between that.
All right, friends.
29 and 30 both are same. Explanation also.
31.
You say that this Supreme Court judgment is not applicable.
No, my lord, that I cannot say, my lord.
This is recovery, no?
That, yes,
Tarsan.
yes, my lord. That we
Tarsan
are relying
Singh.
that Tarsan Singh, that we are saying he is covered by that judgment. Honorable Single Judge has said no, that Tarsan is not applicable.
Or not.
That is the only point to be decided. That 3 years limitation from the date of filing or from the date of its approval.
Yes.
31.
31 relates to work church establishment regulation. Madams have already fixed to the 432 of 22, WA 432 of 22.
It will come.
My lord,
It will be listed.
It was last listed on Friday.
Oh, no. What do you want to say?
So, last week also on other matters, my lord said that after that disposal, these matters will be taken.
Oh.
There is a delay. 159 days, 165.
For that segregated list. Segregated list.
No, my lord, it's not a work church, my lords are hearing, one batch. Other matters, where delay is there, my lord said that, okay, these matters will come after the judgment in the
Ah,
first
that
paper,
is
there
what,
is no.
that is what, second category.
Second category, delay.
8 weeks. 8 weeks. As requested on behalf of the state appellant.
Madam, the second category matters on 26th. 26th April.
26th. 26th.
Second category limitation of CJ.
The leading case will be 819 of 2021. It will be tagged to that case.
Work church.
Item 32.
To my lord, may kindly see, the order where, I will not take my lords to delay because, my lord may, because on merit, I don't have a good case. On 21/10/22, the order is at, annexure 10, page 84. My lord, may
32.
kindly-
469 days delay.
My lord, I'm not taking my lords to delay part now. What I'm trying to, my lord, may kindly turn to page 83.
86.
My lord. 86, no, I'm sorry, 86. My lords will see that this honorable court has passed order to implement the OA order. Now, this OA order is not under challenge. So similar matter also, my lord, just last week, my lord, same order may kindly.
Do you have the number, case number?
Case number, my lord, I'll provide. My lords have dismissed because the main OA order has not been
Right.
challenged, and on the ground of
We
delay.
might not have said that. We might just noticing that fact, we must have dismissed the
And on the ground of delay.
on the ground of delay. Oh, just give the details. Details later. Order like you.
My lord, may kindly permit me to give it during lunch.
This 795 of 2019 OA. You are not challenged.
That has not been challenged. Without challenging that, how do I challenge the reach order?
Item number 33.
In item 33, I'm appearing for the respondent, my lord. There is a delay of 384 days in filing this writ appeal, my lord. So what do you want? To be dismissed. No, writ appeal filed by the appellant should be dismissed on the ground. I am very liberal. Well, a delay of more than 1 year, my lord. Yes, what is the explanation?
Well, there is delay.
Delay.
But-
There may be delay, but there may be explanation also.
My lord, sir, we have tried to explain that.
In your office, files are not misplaced and there is a delay in filing. It happens in your office.
I will pray, my lord, may kindly hear me at least. If my friend says that he's appearing, let him file an objection to it. At least I will have an occasion to address my lord on some, at 2-3 lines on merit.
No,
Page 44 and 45. If my lords are not convinced, I will not press.
no, how can we see the merits?
There is delay, my lord, 384 days delay.
All right. What is there? What is there on merits?
Merit, my lord, may kindly see page 44.
Yeah.
I will only read para. There are 2 paras I will read, my lord. London Counsel for the petitioner contended that similar matter had come for consideration before this court in WPC number such and such, and relying upon the judgment of Apex Court in Union of India versus Prithvirathananda, this court has already considered and disposed of the same by the order dated 13/12/18. Therefore, this writ petition may be disposed of in the light of the said order, to which London Standing Counsel appearing for the School and Mass Education Department has raised no objection. My lord, because the order is to be considered in terms of that order. Then, my lord, in the view of the matter, the order dated 7/12/20 is quashed. The writ petition stands disposed of in terms of the order dated 13/12/18. My lord, we have no occasion to consider that. We have, Honorable Court didn't give us any occasion to see whether it is.
No, but the order was passed in your presence.
My lord, we have to consider that. If such an order is there, if the petitioner's case is covered by that case or not, that is what my humble submission to this honorable court was, the concession
But
given
the
by
order
the.
is- Order attained finality.
My lord, my humble submission, our submission to this honorable court was this, that yes, there is an order and the petitioner claims to be covered by that, and
But you could have told that thing before the learned single judge at page 45. Therefore, this writ petition may be disposed of in the light of said order. So, up to this, it is counsel for the petitioner.
My lord.
Thereafter, to which learned standing counsel appearing for, you did not raise any objection. You did not say that we will examine whether it is
my
applicable.
lord, we understood it to be that, my lord. In the light of that order means we thought, my lord,
Therefore,
are giving
when
me
you
that
saw the
opportunity.
order, when you saw the order, you could have
Filed again.
filed a review, a recall, or whatever.
I will file a review, man.
Counsel for the appellant, after some argument, seeks permission to withdraw this writ application with the liberty to seek review of the order which is under challenge in the present inter-court appeal. The appeal is dismissed as withdrawn with the liberty as sought for.
Item number 34.
In item 34, my lord, 22 days delay.
Yes, wait for the other side.
Support.
Condone.
Support.
Should we condone the delay? Third Learned Counsel appearing on behalf of the appellant. And 1219. 1219.
Well,
I know.
1219
of. And Learned Counsel representing the respondent. There is delay of 24 days in pursuing this appeal. Also, considering the explanation put forth by the appellant in this application, delay stands condoned. IA number so and so, this application is allowed. Yes. List this matter as this appeal as a fresh case under appropriate heading.
Item 35.
No, there is a delay. This is 35, 36 common judgment. There is a delay of 32 days and one is 36 days. My claim is that file could not return from the honorable court or it is website uploaded, so we could not file it in time. That is the ground I have taken, 32 days. And this is also virtually the case is a covered case of by the Supreme Court.
No, notice will have to go, no?
My state is there.
State?
Only
Yes.
state.
You cannot oppose. You don't have.
Small days delay I cannot oppose because we are praying every day. 300 day delay.
IA number 1663. IA number 1663 in first case WA 517 of 2024. This application has been filed for condonation of delay of 34 days in preferring the appeal. Stop. Considering the averments made in this application, the and submissions advanced on behalf of the parties at the bar. This, on behalf of the parties, this application is allowed. The delay stands condoned. 35, 36. 36 में 196, what is it? 1664. Yes.
Yes, same. This virtually the case has been now decided by the honorable. Can be taken up in the case in this week? Can we dispose?
What is this? What
The
is
case
the
is
next week is?
Let it come next
I'm
week.
giving him the judgment. That was also filed in the before the honorable single judge. But in honorable single judge has not dealt with that. Otherwise, it could have been allowed.
I'll verify, my lord, if
I'm
it's
giving that
covered by the
Dhananjay's
judgment.
case. I'm giving him the copy. If my lord will permit me, I can file it the judgments also here.
No, okay, can the appeal be disposed of right now?
No,
Yes,
the
yes, it
day
can
after,
be.
your lordship, call this matter
If my friend will
day-
agree,
day after tomorrow or tomorrow, so that I can,
Let the matters come.
my lord, day after tomorrow,
List this matter. List this appeal as first case under appropriate.
shall I give the judgments?
You can give the reference to Mr.
Yes,
Kutia.
yes,
so
they
that
are on
he can
record. I'm
examine
giving
it.
the copies. I'm giving the copies.
Yes.
That Dhananjay's case, Supreme Court upheld kori, that has been implemented. Let us do. Next time.
Item 37.
Hi, may your lordship. Your lordship, an IA has been filed by the petitioner for the delay condemnation of
How
48
much?
days. 48 days, your lordship.
40,
48.
48. Who is on the other side?
my lord, I am
State.
But no. Yes.
Obliged, your lordship.
51 days delay is shown. By the
51 days.
51 days delay is shown by the.
For admission, item 38.
May it please my lords, the proceeding from out of which the appeal arises was under this transfer of removable property by scheduled tribes regulation 1956, which is shortly called as regulation 2 of 1956. That created a prohibition so far as transfer by a scheduled tribe. And what has happened here, a lady transferred it. She was scheduled tribe. A plea was taken that she having married to a non-ST, then prohibition will not be applicable. This was torn down by the authorities. And the order that was passed by the authorities under the Act came to be challenged 6 years after. And the Honorable Single Judge, my lord, was pleased to set aside the same. As your lordship will find, probably the explanation 1A to section 3 of OSA transfer of immovable property by scheduled tribes regulation 1956. This escaped the notice of the Honorable Single Judge, for which the Honorable Single Judge held that she, having married to an honesty, she will be treated as an honesty.
What is the direct decision of Supreme Court on this?
My lord. And my lord.
Marriage will not change her class status.
Yes, my lord. And the explanation here, my lord, the statute, the regulation 2 of 1956, the explanation makes it clear that even by marriage, her status will not change. That is the explanation. And some time back, I am recalling that even in Jharkhand.
That election petition,
Yes,
election matter.
my lord. There also it was in the light of Odisha amendment was carried out. This has escaped the notice, my lord. Probably for that reason, your lordship will find that even in the impugned.
What is this AHO?
AHO, my lord, then it was being registered as AHO, appeal against High Court orders. Now it is writ appeal. Nomenclature is only changed. This is the short question.
And who is for the other side?
I am appearing for the respondent number 2A.
Subsequent purchaser.
Come this way.
Who came after 6 years.
Scheduled cost. এটা OSC
Go ahead.
We are the subsequent purchases. What has happened in the year 1964, the alleged sale has been effected. Thereafter,
Just let us be clear on law first. Yes. Which provision you are referring to?
My lord, Rule 3.
Regulation 3 or Rule 3?
Rule 3, my lord. Regulation 3, my lord. Sorry.
Regulation 3.
Yes, my lord. Here your lordship will see explanation 1.
But this will we have to refer to earlier statute, earlier regulation.
Regulation 2 of 56. my
No,
lord.
this is of 2002. This was amended in 2002.
So this judgment is prior to that. The cause of action OJC is 99. So year of Purana Bhaita.
This appeal is of 2001.
My lord.
So therefore, we will have to see.
Transaction must be earlier to that. As it stands on the date of transaction. has to be seen. Not the-
My lord, explanation 1.
Was the pre-amendment position.
That, my lord, exactly.
please come to, you must have seen by now.
I am not having your lordship.
Please read it. Please examine that and then.
Day after tomorrow, my lord.
Yeah. Old one. As-
I'll come up with day after tomorrow, my lord. One thing may also be there, if a clarificatory explanation is added, that will be deemed to be there. I will come with, if a clarificatory amendment is made,
This is no clarificatory, it's substitution.
yes, that has
The
to be
whole
examined,
body has been substituted
my lord.
of regulation 3.
I got it, my lord.
As requested on behalf of the appellant, list this matter on Wednesday.
My lord, obliged.
I don't know, 39.
Yes.
This matter, your lordship may recollect, I am appearing as an amicus here. This is, we have given a note, the main issue which your lordships took up on the last occasion, that is wide order number 53, dated 12/4/2024, wherein your lordships have taken note of that recent Supreme Court order and have also quoted that, paragraph 10.
Yeah.
And clause 6 of that paragraph has also been underlined.
Just a minute, just a minute.
My lord, I'm so sorry.
Yes, member secretary has joined.
Yes,
Yes, yes.
No, sir. Yes, my lord. Your lordship, in obedience to your lordship direction on 12th of April, we have had a virtual meeting with all the chairpersons from district judges and secretary. And there we apprise your lordship's direction to effective implementation of the SOP laid down by the Honorable Supreme Court of India at paragraph 10 of the judgment of so motu writ petition 4 of 21. And your lordship, we have, as per your lordship direction, we have submitted the a report with complete list of the prisoners who are languishing in jail custody. Your lordship, so far from the list, my lord, as on date 15th of April, 75 UTP have already been released on bail. And we are taking steps as per the as per the direction, we are filing our DLS secretary are filing the socio-economic report and some modification of bail so far as legal aid counsels, legal aid cases are concerned. my lord.
So how many are still there? 75 have been released.
Yes, my lord. And 5% have been acquitted and 4% have been convicted from the list.
Oh no, whether those who have been granted bail,
Yes, my lord.
all of them have been, you are saying 75 have been released.
Yes, my lord.
Others are still in jail.
Yes, my lord.
So how many are there? How many are there? Do you have the report with you?
369.
Page 69.
No, 360. 369.
369 of the. You get that?
My lord, once I can, from the list, it shows that his latest report is at flag 144. Yes. That is a report dated 19th of April 2020.
That is not common record. Flat 144.
144.
That has not common for physical form. Physical.
Lordships will allow me, my lords, what I
No, physical form.
gather, my lord, the stumbling block here is that the Supreme Court judgment in para 10 clause 6 says that you have to suo motu take it up. That there is some issue in implementation where private counsels are there. Obviously, these are poor people, so they can't, probably the counsels are also not keen. This, if that can be probably said, something can be said about that. The courts have to actually suo motu take it. That's what the Supreme Court says. That is the catch.
Sometimes, Mr. Mishra, even the accused persons are not willing to furnish the bail bond. That is for a different reason. That suppose an accused is in custody in connection with 3 cases. So, and in one of the cases, he is granted bail. He would not furnish bail bond because the period of stay in the court, in the custody, shall be treated to be period spent by him in custody in connection with that case. So that may also be
that's in fact the
one of the reasons.
member
They'll have
secretary
to-
has been kind enough to give the list of all cases. So about 60% of these numbers are multiple cases. So that is one issue where multiple cases. So say out of 333, if we reduce about 60%, rest 40% is something which they can work towards bringing it down.
And
The 1978 and thereafter, they have said that if you don't impose this bonds and sureties, you can always release them on PR bond.
they decline.
But that probably is not being done here. They are still going the conventional way of going for local sureties and bail bonds.
No. Court's question is different. So if they are not in a position to furnish bail bond, the courts observes that they can be released even on PR bond. But if they are not ready even to do that, not the accused persons, those who are in custody. So whether the court, you are saying court should take suo motu notice. So whether the court can force him that see there is a bail order, you will have to go out now. Furnish your PR bond.
Possibly that can't be done, but I think we have not come to that stage. This PR bond, offering PR bond in terms of para 10(6), that exercise probably is not being done in the manner in which it should be done, because the Honorable Supreme Court says 1 month. Thereafter, you take it up suo motu. I think the London member secretary can throw some light on that. I think that's where they are facing problems, because the councils are not moving the matter. The private, wherever these legal aid councils are there, they are actively on his direction, they are moving. But where private councils are there, they probably are not coming forward with this. That's what my understanding is. He can probably throw some light on that.
Yes.
Your Lordship, in 333 cases out of the 444 is the private counsels. So far as legal aid cases are concerned, my lord, 95 cases are there. So we are taking steps for filing the socio-economic report and modification of bail. And my lord, there are 197 multiple cases are concerned. So my lord, private counsels are concerned, my lord, we are only requesting the private counsels to file modification of bail before the concerned court.
No, you will have to contact the prisoners.
Yes, ma'am.
On individual basis.
Mr. Acharya.
Yes, ma'am.
What Mr. Amicus Curiae says, that court has to take up such issues suo motu.
Yes, ma'am.
So notwithstanding that the private counsels are not moving or they are not taking care, the
Yes.
court can intervene and
Yes, ma'am.
so much to take step into their aid. Can't it be?
Yes, ma'am.
That is what he wants you to throw light on.
Yes, my lord, as per the SOP laid down by the Honorable Supreme Court, the bail bonds are not furnished within 1 month from the date of grant of bail. The concerned court may so much to take up the case and consider whether the condition of bail require modification or relaxation. Your Lordship, in para 4 of SOP, our part is concerned, so far as legal aid is concerned, the Secretary DLSA with a view to find out the economic condition of the accused may take help of the probation officer or the PLV to prepare a report on the socio-economic conditions of the inmate, which may be placed before the concerned court with a request to relax the condition of bail shelter. So we are collecting the socio-economic report of the concerned UTP and placed it before the concerned court. And thereafter, as per para 6, my lord, the role of court is there. So considering the socio-economic report, the court may relax the condition of the bail, irrespective of private or legal aid counsel.
So how have you proceeded so far? How do you contact them? Like if someone has engaged a private counsel,
Yes, ma'am.
then you approach the private counsel or the accused also?
We are requesting the private counsel, my lord. And during our jail visit, the DLS are contacting the UTPs, but we are requesting the private counsel to file modification of bail bond before the concerned court.
No, but this is what we are saying.
Yes,
that if you approach the accused in jail,
yes, ma'am,
and tell him that, see, you have been granted bail and the conditions for release can be relaxed. If you agree,
yes,
then he may. Otherwise, if you ignore his case only on the ground that he has a private counsel, then it may become very difficult. We don't know no one knows in what circumstance the counsel is not taking up his matter or what, his private counsel. So why the legal service authorities should not approach them individually? Paralegal volunteers are there. In every jail you must be having paralegal volunteers.
Yes, ma'am. We will contact personally.
The superintendent will tell you, the jailer, they should take up the cases on individual basis.
What's also, my lordship, is actually also there in that SOP 10.2. If the accused is not released within a period of 7 days from the date of grant of bail, it would be the duty of the superintendent of jail to inform the secretary DLSA, who may depute paralegal volunteer or jail visiting advocate to interact with the prisoner
Exactly.
and assist the prisoner.
This is what
exactly it is, the Supreme Court directive. So 7 days window, thereafter they have to.
And
start
if you
the
are not
process.
doing, you are committing contempt of court, everyone.
Our jail visiting lawyer and paralegal volunteers are visiting the jails and
Cannot allow you to violate the orders.
And that to assist the prisoner in
Yes,
all ways possible for his release.
Yes, ma'am.
That is also that.
This is what, yes.
This is very important. So we have to find out all ways. To help him.
Only on the ground that they have engaged private counsel.
And 10.3, they have also made a technological advancement regarding automatic information to DLSs. 10.3, it is also quoted in my lord's order, where an email would
NIC.
my lord,
NIC.
NIC to in that software. So I'm not sure whether these
have not been done, my lord.
Plus the software.
I think the prisons department, they have made advancements during the earlier time. I think the state council can say that I think this.
Which is a very serious matter.
Yes, madam.
It is, it cannot be taken up so lightly. We are just giving you an illustration. The report which you have submitted. One Alad Bardhan. He was granted bail on 5/3/2024. He has a private advocate. The reason for non-release is non-availability of solvent surety and nothing else. Requested private advocate. Forget private advocate.
Yes.
These matters are not being taken up in with due sincerity.
Mr. Ishwar, you have any e-prison software
Please.
as reflected in the
Whereas I'll have to take
point
it.
number 3.
I'll take instructions on whether there is a e-prisons.
NIC would make attempts to create necessary fields in the e-prison software so that the date of grant of bail and date of release are entered in by the prison department.
Where is that, Mr. Mishra, the SOP?
That is there
in our
Page
Your
136.
lordship have also quoted that.
24.
Page 137.
In the note also I have given the entire judgment. My lord's previous order number.
We have extracted.
Like if my lord is seeing that table, we have identified some of these cases where it would be very serious, like entry number 79. And mostly it would be from those.
That is flag 143.
My lords, flag 143, the report which was shared, entry number 79. I think the serial numbers will all match because the same 444. Now, in the meanwhile, in these 15 days, further prisoners, further UTPs would have been granted bail. Those numbers have not yet come into the picture. Now we are still dealing with 444. So as these matters progress, people will be further released, then these numbers would then, I'm told that they will increase. So some of these instances, my lord, would see.
Inability to furnish bail bond is in most of the cases.
No, all these are inability to furnish, or the entire list is inability. My lord, may see
some
from
cases involved in multiple cases.
Or we will take up the matter tomorrow again.
Your Lordship, I am appearing for the interveners in this case. I have in this case, IA number 8807. We had filed the intervention application based on two major grounds. That was one is with regard to the development of SC, ST and OBC children in the OBC category of children in the the under trial prisoners and UTP and the diet of the under trial prisoners who divided into two categories, laboring and non-laboring. The second ground that
what do you want?
Your Lordship, on the last occasion, the state had sought time by their by their affidavit stating that they need some more time with regard to give any instruction with regard to the development program that has taken place. So I'm just seeking a clarification. So if they can.
Intervened in the writ appeal, and also I have filed a petition for recalling the order in the writ petition. I have also filed a writ appeal number 738 of 2024. I am the aggrieved party in the sense that in 1923, the property was leased out to me. In earlier writ application, I was made a party, but in the present writ application, I have not been made a party, and the order has been passed. The matter is ready for admission. Can it be taken up? I beg your pardon.
In this case, his intervention application has been allowed in my appeal. He was not a party there, and he has approached the Honorable Civil Court, and Civil Court is session over the matter. Can he parallelly prosecute the case now? He is now taking advantage. Several adjournments are there from various parties.
And I have approached the Honorable Apex Court for release of that document. The registration is completed and my registration is under challenge in this writ appeal, seeking for a declaration that my sale is void. And your Lordship, after hearing your Lordship put a very pertinent question, two questions. Even if there is a sale deed, can ipso facto it gives a right on the purchaser law. I have come up with that judgment. Recently it is held by the Honorable Apex Court. It doesn't give a right on the purchasing law. The vendor doesn't have the right. Certainly will not right, no right will flow.
So whose appeal is this?
That state's appeal.
We have filed one appeal and he has filed another. There are two appeals analogously being heard. The only question is that whether the.
Please come this side.
Because
You go that way.
The sale deed presented by the respondent number one, not the respondent number one. The respondent number one is the buyer. The pro forma respondents are the sellers. They presented a sale deed before the district sub-registrar Puri.
Who is buyer?
Buyer is the present respondent number one, Manas Kumar Pradhan.
Yeah.
And seller is the pro forma respondents to this appeal. I'm just placing their names. These sellers, they claim to be the successors in interest, descendants of one Harsarani Dasi Mukhi, who was the ex-intermediary in respect of the suit land in question. They are claiming that we are the successors and descendants of Harsamukhi Devi, Rani Harsamukhi Devi. That those pro forma respondents are, yes, Vikas Chandra Sinha and Aninda Sinha.
Yeah.
They presented the sale deed claiming that we have inherited the suit land from Rani Harsamukhi Devi and as such we are the owner of the property and we hereby present the sale deed to sell it in favor of the present respondent. That was refused by the sub-registrar and that order of the sub-registrar was confirmed by the appellate forum, that is the ADM, ADM Puri, and thereafter this present respondent number one challenged it in before the Honorable Single Judge. Before your Lordship will proceed to the merit of the case, I will only point out two pertinent questions. Recently in a case, the main question on who is the there was a refusal of registration, that is for section 22A of the Indian Registration Act. Recently your Lordship has dealt with in one case. Admittedly, this suit land stands recorded in the name of the state government in the finally published record of right of the year 1987-88. There is no dispute to it. This property sought to be transferred at the instance of the pro forma respondents in favor of the respondent number one stands recorded in the settlement record of right of 1987-81 in favor of the state government. This is the admitted fact. The second admitted fact is that these pro forma respondents, they have preferred a revision before the revisional authority under section 15B of the Orissa Survey and Settlement Act. It is their case for correction of that recording and to insert their name in place of state of Orissa. Now section 22A your Lordship has held in that case, in that I will place that order of this on the report, that section 22A bars that no registration of sale deed in respect of the land which is recorded in favor of the state government, that is forbidden. And that section 22A, that part has been challenged in the writ petition in virus of that. And the similar matter, today also it is in the list, that is a writ appeal Golavardhan Power, that is in item 37 or 39. I will only place that order which your Lordship has passed in that appeal because it is similar to this. We are of the practice. This is also refusal of registration by Sambalpur DSR. Your Lordship may go to para 3. We are of the prima facie view that there being specific provision under section 22A of the Registration Act, which has been introduced in 2014 by way of amendment, the rejection to register the document in the facts and circumstances is justified. Learned counsel for the appellants, after having argued the appeal at length, has submitted that the validity of section 22A of the Registration Act is under challenge before this court in WPC number so and so and batch of matters. He submits that he shall be pressing this appeal after the question of validity of section 22A of the Registration Act is decided. This matter is also in the list in item number 39. So my respectful submission is that the sole ground of rejection of the prayer of the respondent number 1 is that by this the registering authority is that the property stands recorded in the name of the state government as per the settlement record of right. So section 22A is a bar. Government property cannot be alienated at the instance. Now,
there is no question of government property being alienated. Because person who is not the owner cannot transfer ownership.
Yes.
So even if the deed is, a document is registered, or even if sale deed is registered, the property cannot stand transferred.
That
Just
is-
mere.
But once the sale deed is registered, now your lordship may kindly visualize the subsequent effect.
We don't visualize anything.
Because he will claim title over the
May
property.
claim whatever the claim can be declined.
But section 20A,
That is
22A,
different. That is different.
that is why your lordship, similar argument was placed by the
There you are
appellant.
right. Because of section 22A, you have a case. In
Yes,
the
ma'am.
absence of section 22A, you don't have any case.
That is there. In that case also, your lordship has similarly opined that because of section 22A, you have a case. Your
Right.
lordship has gone through that provision. So that is why your lordship has.
Otherwise, there is a Supreme Court's decision.
Now, that is why your lordship, the legislators have also made the provision. The appellate authority is ADM, and section 72 provides that the ADM will decide the appeal against the order of the sub-registrar. There the law is that if the ADM's order is found to be illegal, then the aggrieved party can approach the civil court for his restitution, for his redressal of his grievance. So the alternative remedy is civil court, not the writ petition. Because he has filed, that is also ground taken in the writ counter affidavit which I filed before the.
Yes.
So my respectful submission is that 22A is a bar, so there is no illegality in refusing the.
So that is the question involved in here also.
There are other questions also, but this is the prima facie. Because of this order, I intend to place this fact. Now, what is the ground of the other side? He is saying that in view of the Dhobal Pradhan's case, that is a case law of this court, which was also placed by the learned counsel of this case before your lordship, that section if the party can successfully prove the flow of title, then from the recorded owner till the present person presented the who is presenting the sale deed, then there is no bar in allowing the registration. That Dhobal Pradhan case. Your lordship will see that Dhobal Pradhan case is reported in 2014 to OLR 902. My lord, what has happened in this case? I may be permitted to place the facts of this case because that is very important. X has presented the sale deed for registration, but the ROR stands recorded in the name of Y. That was rejected. But the fact is that there is a sale deed transferring the title from Y to X. So the court has held, honorable court has held, since the Y is the recorded owner and there is a sale deed from Y to X, so there is a clear case of flow of title. So you cannot prevent X from registering the presenting the sale deed for registration. That is the facts of the case. So section 22A is not a bar if there is. But here is a case. What I intend to submit before your lordship. Here is a case. There is the government is declared to be the owner of the property as per the record of right in 1987-88. He is claiming that by virtue of a apex court honorable Supreme Court's decision, which was passed in 1955. I am the owner of my predecessor, 62, I'm sorry, 55 years back. I am the owner of the property. My predecessor, Harshamukhi Devi, was declared to be the owner of the property. That is a disputed question of fact, which I have dealt with in my counter affidavit by saying that the order of the Supreme Court, honorable Supreme Court, is not clarified to the extent that the possession has not been taken over by the party, that is the ex-intermediary, and the judgment has not been carried out. And by virtue of that possession, etc., the settlement authority in 1987-88 again recorded the name of state government in respect of the suit land. So this Dhabal Pradhan case and our case is distinguishable, not similar to the facts and circumstances of the case. They have no cell deed, nothing. Admittedly, it is a government property, and only they say that in 1962 there was a judgment of the Honorable Apex Court by virtue of which their predecessor Rani Harsamukhi Devi was declared that she is a royalty in respect of this suit land, and the notification under Section 3 of the OEA Act to take over the land under the Orissa State Abolition Act was declared to be null and void. But fact remains, it is also the admitted fact that despite such judgment, the possession which was taken over by the state government by virtue of the OEA notification has not been restored in favor of the ex-intermediary. So possession remained, and by virtue of such long possession for 33 years, again this suit land stood recorded in the name. So these are the disputed questions of fact involved in this case, so far as the title of the present and respondent number pro forma respondent 3 and 4 of the. So Dhabal Pradhan case is a clear case where the vendor of the person who is presenting the sell deed, he had the record of right and he had sold the property to the person who is presenting the. So this case is distinguishable. This is one part of the case. Another part is that which other interveners are also pressing. This is also one of the ground. This particular property is situated within the Sweetwater zone of Puri municipality. Sweetwater zone is, there is a clear prohibition that notification is also there, that it is not alienable. So that is also even if there is a title or something which they claim to be the owner of the property, according to this notification, it is not transferable. But my preliminary submission before my learned friend starts is that Section 22A is a bar, and your Lordship has recently held in this order that unless that Section 22A is quashed in the writ petition which is pending before this Honorable Court, virus of which has been challenged in WPC number 16235 of 2016, this case should not be taken up for hearing, and it may be tagged with this because these are two similar cases. This is Sambalpur district, this is Puri district.
And what is the second writ appeal?
Yes, mine. I am fine.
Who are you?
I am the resident of Puri town. I am a journalist. My lord, I have filed this writ appeal.
Just a minute. You were party in the writ proceeding.
To my lord, not my lord, this honorable court has granted leave to file the appeal. This honorable court has granted leave and allow me to file appeal, my lord. As my lord, the land is the only question.
Where is that leave? Where is that leave granted?
Yes, my lord.
In which case the leave was granted?
My lord, writ appeal number 141 of 2022.
Yes, we have seen the order.
My lord, I am the appellant and my appeal tag with the appeal filed by the state government, my lord. My lord, my read appeal tag with the appeal filed by the state government, my lord. And the sale deed executed by the district supervisor of Puri on the basis of the order passed by the Lord single judge of this Honorable High Court, my lord. My lord, the petitioner filed the read petition under Article 226 of the Constitution of India, when his revision pending before the director to settle the land.
So you are making same submissions which has been already been made by him,
To my
the
lord,
state council.
my lord, another important point, my lord, as I am the resident of the Puri town. My lord, the land in question situated in the reserve waterworks area, popularly known as Sweetwater Zone of Coastal City Puri, from where I, along with lakhs of residents of Puri town, getting drinking water since more than 50 years, my lord. And the Odisha State Coastal Zone Management Authority has imposed under restriction under Section 5 of the Environmental Protection Act on a transfer of the land in that ecological sensitive area. My lord, the Honorable Appeals Court in the case of MC Mehta versus Kamal Nath reported in 1997 Supreme Court cases, the Honorable Appeals Court held that the state is the trustee of all natural resources which are by nature meant for public use and enjoyment.
Yes.
Public at large is the beneficiary of the seashore, running waters, air, forest, and ecological fragile lands. The state as a trustee is under a legal duty to protect the natural resources. These resources meant for public use cannot be converted into private ownership. My lord, this is a landmark judgment of the Honorable Appeals Court. So I pray, my lord, as this land in question, which was illegally registered by the Sovereign Puri on the direction of the Honorable Single Judge of this Honorable Court, situated in the reserve waterworks area, the Sweetwater Zone of Coastal City Puri, my lord. Therefore, if this Honorable High Court will not cancel this, set aside the order of the Lord Single Judge, and the so-called registered deed will not be cancelled, I, along with the lakhs of residents of Puri town, tourists, and the public, will be suffered to get the required in the future, my lord. So I pray, my lord.
No, but already an appeal has been filed. He is also taking the same plea which you are taking.
My lord, as a citizen of this country, first I have filed this writ of appeal. After 2 months, the state government has filed. First, my lord, I have filed this writ of appeal.
Which resident of Puri is not entitled to file an appeal?
Yes, my lord.
Which resident of Puri? What is the population of Puri?
But 2,50,000, my lord.
2 lakh writ appeals can be filed?
No, my lord.
Why?
Why
Anyone can file?
Yes, my lord.
Everyone.
My lord, the case involves the fundamental rights of a citizen of India, which is guaranteed under Article 2 or the 12 of the Constitution of India, my lord. As my fundamental rights violated.
Please, the appeal is being argued with the same vehemence.
Yes, my lord. Yes.
With which you are arguing on behalf of the estate. If required, we will hear you also.
Okay, my lord. Yes.
Almost similar ground he has taken. Lordship can deal with this. Your Lordship may see page 16 of the appeal memo. I have given all the grounds on the basis of which I have preferred this appeal, including section 22A, alternative suit, section 77 of the Indian Registration Act, and more particularly that the record of right is admittedly in the name of the state government, and for that he has filed a revision before the competent court of law, revenue court, which is pending sub judice. So unless that revision is allowed in his favor, he cannot claim that it is not the government property as per the record of right. He simply cannot ignore a public document by saying that it is not, it is erroneous on the face of the record. If it is erroneous, then you have challenged the appropriate court. Let the court decide that whether the record of right is correct or not. Till then, this state's right over the property, title over the property cannot be disputed by a private individual. So if it is a government property according to the 1987 ROR, the 22A is a bar. What your lordship is saying that section 22A is the only point which I can canvass before lordship justifying the order of the registering authority because it is a government land. And that ground I have taken in my appeal memo. And similarly, the sweet water zone position.
What is the decision in by Supreme Court in year 1962 Supreme Court 1912?
That is the decision that was filed against the order of the OA collector by the ex-intermediary. And in that case, so far as this OA notification under section that was declared to be void and the royalty status according to them, according to the Honorable Court's decision, the royalty status was restored in favor of the Rani Harsamukhi Devi, the ex-intermediary. But the possession which was taken over by the state government was not restored. That is the specific stand of was not restored in favor of the ex-intermediary. That is the stand which we have taken in the counter affidavit. There was no order to that effect by the Honorable Apex Court, nor any endeavor has been made by either by the ex-intermediary, the Queen Rani of Harsamukhi Devi, or her descendants to take over, restore back the possession in respect of the land in question.
So what does that mean?
My lord?
What does that mean? The land.
That means this section 3, the notification under the OA Act, that is declared to be illegal. So far as this property is concerned, the OA collector has no authority to notify to take over the land. But In the meanwhile, the land is already taken over by the state government and it is already as a state government land, it has been
Under
recorded.
which provision?
Under the OE Act. There is no dispute in the
What?
Orissa State
Let us
Abolition
see.
Act.
Oh, let us see this decision of Supreme Court.
Yes, my lord. It is Annexure 1 to the appeal memo. আপনি দেখেছেন বহি আছে বহি
No, that judgment, Supreme Court's decision.
Yes, ma'am.
It is there.
Yes, Annexure 1 to the writ appeal, page 39.
That is not Supreme Court judgment.
1962 Supreme Court decision.
62.
62. 62 Supreme Court.
Yes. Yes. 62 Supreme Court 1912.
Where is that?
That is Annexure 1, paragraph 5 of the appeal memo, may kindly be seen. Paragraph 5, page 26. The above judgment of the apex court reported in so and so.
Where is that judgment? Do you have a copy of that judgment?
That is Annexure 1, page 39.
Annexure 1 is not a judgment.
Civil appeal number 177 of 1960. Judgment.
Annexure 1, no, it is not there in the writ petition.
This is civil appellate jurisdiction, civil appeal number. Oh, this is Annexure 1 to the appeal, writ appeal.
Yes, we are at appeal.
No, it is not there.
I'm sorry. Writ petition Annexure 1, I'm sorry. Writ petition is there in the writ appeal. I'm sorry. Appeal memo 39. I'm sorry. Appeal memo 39 page. Writ petition Annexure 1. Page 48.
So despite the Supreme Court's decision,
my lord.
it is your case that state continued with the illegal possession over the land.
With the possession of the land and
Illegal.
because the Supreme Court has held that the possession is illegal. Yes, my lord. That
And
the
you are
state of-
you are basing your case on possession only.
And basing on that possession, the record of right was prepared in 1987 in favor of the state government. Because she made no effort to take over possession or restore back the possession on the basis from she slept over the matter after the Supreme Court's Honorable Supreme Court's judgment. There is no scrap of evidence that what happened after this, because she has applied for restoration of the possession, and that has not been made, and the government continued to possess. In 1987, settlement operation started, and it was recorded in favor of the state government. Till 2024, the matter
Wrongly
is
recorded.
Sir,
Wrongly recorded.
Illegal possession.
that wrong recording is challenged before the appropriate revisional court, because what I beg to submit, if now your lordship will give a finding that it is illegal recording or wrong recording, it will affect the merit of the RP case, which is now sub judice before the court competent to hear the RP case.
So the finding by the Supreme Court will
That is
prejudice
also- that-
will prejudice the case.
No,
before
that
the
he
revisional
has
court.
taken that ground in the RP case. That he has taken that ground in the case which is filed with the revisional.
Finding, Supreme Court's finding in this case will prejudice the case which is pending before the divisional authority.
No, divisional court, he has taken this ground, and government has taken the ground that for more than 30 years, you did not take over, applied to take back the possession, restore back the possession, government continue the possession, and settlement authority recorded is. That point is to be adjudicated according to my responsibility.
Where is the law? Where is the law that because you were in possession for 30 years, therefore you acquired the right title and interest for the property?
I will examine on
Where
this.
is the
And
question of will?
no, my the sub-register, the impugned order reveals by the registering authority that this is of 1962 and till 2020, no application or no effort has been made by them.
What effort? Supreme Court order, so finding is there. What more effort?
She could have applied for restoration of the land. That is what subject to a lordship's acceptance.
That constitution.
This is constitution by decision.
My lord, order passed by the Honorable Supreme Court is not applied in this case. Because, my lord,
Why?
my lord, the Honorable Supreme Court passed order, it must be held that the appellant royalty interest. The Honorable Supreme Court passed order for the royalty land, but the land in question in this case involved is a intermediary and a private land, my lord. So, my lord, order passed by the Honorable Appeals Court in the case of Bimala Chandra Sinha versus State of Orissa, my lord, not applicable in this case, my lord. It's my submission, my lord. Because, my lord, the order passed by the Honorable Appeals for the royalty land only. But it is a intermediate land and a private land.
But the khata and plot number is the same, no?
No, my lord. That different. Thouj also, my lord, different.
This land, I mean, pardon, my lord, this land was leased out to me by the municipality in the year 1923. I constructed the building and I am continuing in that building. In the Honorable Supreme Court judgment, they challenged possession with regard to their kacheri. That is not with regard to this property. That is the point.
What is this Tawji number 268?
Tawji number is in respect of the jamidari. The Honorable Supreme Court said that out of that jamidari, the kacheri land of the jamindar, which is in their actual possession, that has to be settled in their favor. We have no quarrel about that, my lord, Honorable Supreme Court judgment. But so far as this land is concerned, I have annexed that document. I have also intervened in my application. In 1923, this land was leased out to us. And since then, I am continuing in possession thereof. That building is known as Datta Villa. I had sued before the Honorable before the Lord Sub-Judge. There on Lord Sub-Judge decreed that I cannot be evicted from that plot. Honorable Supreme Court, in that case, your Lords may kindly see the judgment of the Honorable Supreme Court at page 24 in WPC number.
No, is there any dispute over the in respect of the land?
Yes, my lord.
That was the subject matter of the land which was subject.
Yes,
matter of-
Tauji is the same, Tauji is the same, but there is different land,
Tauji pertains to the entire Jamindar.
entire Jamid, because
Whether
this,
from the judgment of Supreme Court, it can be said that that was the land, particular
No, my lord.
piece of land which was being
subject matter of
considered
the cell deed.
No,
No,
subject matter of before the Supreme Court.
no, so before the Supreme Court, your Lords may please see page 24
Yes.
of the judgment. That they have taken. It is independent private court.
Royal land, the Supreme Court of the Royal land.
Yes.
At page 24 of the judgment of the Honorable Supreme Court, my lords, the Supreme Court has specified the land as the building in question has been primarily used as office or kacheri for collection of rent or for use of servants or for storing grains by way of rent in kind. That is a totally different land.
Whether this plea was taken.
Pardon me.
Plea was taken before the writ court.
In the counter affidavit.
We were not party, that's why I filed it.
You could have filed a review application.
No, I
He has
I
filed a recall
petition. I have filed a recall petition in the writ petition. I have also intervened in their writ application, and I have also filed a fresh writ appeal, WA number 78.
Yes, please.
And so far as this particular point which your lordship is pointing out, which I find that in the counter affidavit there is no such, that it is our counter affidavit is only in respect of that particular Tauji, which consists of several plots. But what my learned senior is saying, that is evident from the Supreme Court's order that it is only in respect of the Kacheri Ghara, not the land which we are now, the Honorable Court is now in session. So in the pointing out that particular point.
No, Mr. The entire case of the writ petitioner before the learned single judge was based on the Supreme Court's position. On the point that the dispute, the land which was subject matter of Supreme Court's decision was the same land.
Same.
Whether any this fact was controverted.
My lord, so far as your lordship may kindly see the counter affidavit, that is also annexed.
Why should we see you say?
My lord, I am just placing, my lord. Kindly give me some. I am just placing the counter affidavit. That will be better.
Lord, the learned single judge has misinterpreted the order of the Honorable Supreme Court, my lord. I pray, my lord, kindly see the last para of the order of the Honorable Supreme Court, my lord. The Supreme Court very clearly said, my lord, it must
I am warning you. Please don't interject.
Okay. Sorry.
Para page 103 of the writ appeal. Para 8. That so far as abandonment made in para 5 to 7 of the, it is humbly submitted that Paikwarapur estate was vested in the state government by virtue of notification dated so and so. The intermediary at the relevant time approached this Honorable Court by OJC number challenging the action of the state official taking illegal possession of the Tauji in the year 1954, alleging that the property in questions are royalty land and the intermediary and the state official has no authority to take possession of the same in view of the section 5H of the OEA Act. The Honorable Court, while considering the application filed by the intermediary at the relevant time, turned down the claim for which the intermediary moved before the Honorable Apex Court, so and so. The Honorable Apex Court, while adjudicating the aforementioned civil appeal, categorically held that the appellant's royalty interest in the land and in the building standing on those lands have not been affected by the abolition of his interest as proprietors, and that the state authorities had illegally taken possession of those. But the Honorable Court, Apex Court, while disposing of the civil appeal, has not whispered anything relating to restitution of the property in favor of the then intermediary. That it is humbly submitted that after disposal of the civil appeal number so and so, neither the then intermediary nor the legal heirs of the said intermediary approached the authority, OE authority, for resumption of the land, for which in the year 1987, after 28 years of the disposal of the civil appeal number, the suit land was rightly recorded in the name of the state government, and accordingly ROR has been published in the name of the state government, which was challenged by the pro forma opposite party in RP case number so and so under section 15B of the Act before the Commissioner Land Records, Bhubaneswar, after 34 years, which is barred by limitation. This is the ground which we have taken in the counter.
So which provision? Limitation and then limitation.
Section 15B, 1 year from the date of publication of the error, it can be corrected by the revisional authority. It is filed after 34 years.
Service.
No, it is in Survey and Settlement Act.
Survey settlement.
15B. Survey and Settlement Act. Section 15 small b.
There must be something. If there is nothing, then we will have to, there is nothing wrong in the decision of the learned single judge. If you agree, the state agrees that the land in question in the Supreme Court's decision was same as the present one, then you don't have any case.
My lords, so far as the Honorable Apex Court decision is concerned, that is in respect of the royalty interest. But so far as possession is concerned, according to my counter affidavit, it has not been restored in favor of the ex-intermediary or the royalty, the old royalty. So that is the stand taken by the state government in our counter affidavit. Now, another point is being raised by the intervener that this is in respect of the Kocheri land, not the other land. That part, of course,
That point cannot be raised now. If those points were available when the case
in the
was
counter
decided,
affidavit should have been.
when the case was decided before the Supreme Court.
Now while examining the order of the Honorable Apex Court, the honorable court should have considered that whether it is in respect of this particular land or in any other land of that Tauji particular.
You don't raise any dispute, why the court should?
That is the only point which I have raised in para 8 and 9.
You have accepted.
No, we have not, we have only said that there is no restoration of
If you
possession.
don't deny, then that amounts to acceptance. That is the doctrine of non-traverse.
Lordship, this is a very,
This is a very what? We have to decide disputes.
the
We are not
Tauji,
concerned
Tauji
with
is
very or
consist of,
whatever.
Tauji is consist.
May pardon my lords. Actually, I am in possession of the.
All right, your submissions are over?
Yes.
I am in possession of the land since 1923. I was made party by the present respondent in all other writ applications. But in the current writ application, I was not made a party. That's why I couldn't bring all these facts to the notice of the honorable single judge. That this land is not the cautionary land of the respondent. This land was leased out to us in 1923. I am continuing since then. My building.
So when did you file your application for recall of the order?
Immediately after coming to know about the order, I have filed that is pending in the WPC. That is pending. That's why when I came to know that writ appeal has been filed, I also filed an intervention petition. And for abundant question, so that I can place before all the facts before your lordship, I have also filed the writ appeal. That is weird.
Yes, I'm happy.
So why did you not implead him as party?
Well, he is completely rank trespasser, my lord. He was my caretaker there. If he claims that he was in occupation since 1923, then there will be a dispute between me and himself. State is nothing to do.
No, yes. This is what he is saying.
Yes, my lord.
That if you
So there
file...
are two conflicting, my lord. These two, state and the private interveners, they are conflicting interests. State claims that we are in on illegal occupation of the building, irrespective of the order passed by the Honorable Supreme Court. They say that we are in occupation in 1923. The law says, my lord, the Odisha State Abolition Act came in the year 1953. Lock, stock, well, everything.
The question is whether he had a right to be heard before the learned single judge or not.
Yes. Certainly not because, my lord, he has already approached the civil court. Civil court is session over the matter.
You knew that there was...
No, I subsequently came. That after my registration is over, he went to the civil court. Before civil court, he challenged my salary. Subsequently, this Bastia.
Before filing of the writ petition by you,
yes,
you did not know.
I was not aware. I know that he is in a portion of the property. He is encroaching.
Huh?
That much. He was encroaching the portion of the
much you knew that your property has been encroached upon by him.
No. I actually, being a purchaser, as a bona fide purchaser, I was not within. It is not within my knowledge. I am not staying there, my lord. I went through the records and gave the constitutional amendment, get it executed. Out of 1 acre, he is in occupation 10 decimal. So that will not affect. If he will continue, my lord, I will evict him in due course.
Yes. What proceeding was there earlier?
In WPC number 22425 of 2020, filed by the present respondent, my deceased father was made party. But in the present writ petition, they deliberately have not made me party.
Yes.
WPC number 22425 of 2020.
But that was my prayer was
Then
getting
if
limited.
that is the situation, then you have obtained the order fraudulently.
No, my Supreme Court judgment is my lord only.
Supreme Court judgment, nothing can be culled out from Supreme Court judgment.
I can show you, lordship.
Because in the Supreme Court, in the Supreme Court's decision, there is no reference to the description of the land.
That is the duty of the state to come forward. It is not state's case. This is not that particular property. Out of 700 acres, I claim only 5 acres.
So, therefore, any 5 acres can be given to you.
No, not at all, my lord. That is the duty of the state council to come forward and say.
That is your duty. You were purchasing.
Yes, my lord. Whatever the properties I found, my lord, that only out of not a single inch of land has been given by the state, despite of the order of the apex court. Constitutional bench judgment is there.
According to you, you were purchasing based on the Supreme Court's decision.
Yes.
And in the Supreme Court's decision, there is no reference to the description of the land.
It
Then
is
how could you know
Your
that the
Lordship,
land
permit
which you
me,
were
I can show
purchasing?
your Lordship, this is the particular land, how I am claiming. Page 40 kindly, I will claim. Read appeal memo, page 40 kindly. What was my grievance before the collector, before this honorable court and before the apex court? On the land, last 7 lines, your Lordship, 7-8 lines. On the lands of the occupancy holding,
Where
there
are
were
you
several buildings. My lord, your Lordship kindly consider, page 40. Page 40 of the appeal memo.
Yeah.
Last 7 lines, your Lordship kindly. What was my grievance before the?
No,
Order.
you did not have any grievance
Yes.
because you are a purchaser.
No, my vendors. I stepped
Your
in the shoe of
vendor,
the vendor. I definitely stepped in the shoe
So
of the vendor.
your vendor knew about the land in respect of which he was fighting
He has
before
told
the
it.
Supreme
He has
Court.
told it, none else. My vendor has told it.
Mr. Counsel, therefore we are saying that your vendor knew as to which land he was fighting
Yes,
for before the Supreme
That is
Court.
very much in the custody of the government. That is very much in the custody. 7. See, your Lordship, I may be, there is some communication gap. Yes, my lord.
We
What
are-
your Lordship, my vendor must be knowing, my lord. What are these? I have not examined that. I have not examined. I went through this judgment of the Supreme Court, and in the year 1953, few buildings were there. Few buildings, 2-3 buildings
So
were
you
there.
went through the judgment of Supreme
Yes,
Court
my lord.
and you purchased a piece of land, whatever was given by your vendor.
Yes, my lord. Yes.
And on the basis of that, you are saying that you have proprietary rights over the particular piece of land.
Royalty land I purchased. Royalty land, not proprietary. Proprietary and royalty that distinguished in that judgment. Matter. This is a royalty land of my vendor which was not vested. 5H, your Lordship.
None of you have any case. Neither you nor him nor him. No, nothing. Don't have any case.
My lord. And it is specifically declared that the government has taken over this position illegally. And this is the only symbolic position by virtue of this act.
We are
5H.
giving you 2 days time
Yes.
to tell us as to what is the basis for you to believe that the land which you purchased was the subject matter of dispute before the Supreme Court.
Well, it is a proceeding of 1953. My lord. Your Lordship also asked the State Council to get it.
Why? You have purchased.
I have purchased, my lord.
What submission? What kind of submission are you making?
And that is not their case. They are now developing this case.
No, you have to establish your case. You had filed writ petition.
Only last 3 courts, he has
Mr.
not
Counsel,
whispered anything. Rather,
Mr. Counsel, the finding is in your favor recorded by the writ court, which is under challenge before this court.
Yes.
So you had to satisfy the writ court. It is not that the state had to
that
satisfy.
was never the case of the state. That is all difficult. Your Lordship raised a very pertinent question. Was there any case? It is a certiorari writ, my lord. Can they raise any different point in the appellate forum? It was never that case.
Your writ, your conduct.
When he has made him a party, why he has ignored him?
Well, I have not examined that.
Yes. We will hear you again. We will hear you. We are giving him time for a limited purpose as to whether the Supreme Court's decision deals with the land which he is said to have purchased. And if there is any dispute, then that cannot be seen by the writ court.
Pardon me. Can my writ appeal be taken up? WA number 73.
Where is that?
That is
It is not in the list.
Not in the list.
Same judgment.
Whether that has been admitted?
No, it has not been admitted.
Is it defect free?
No, it's defect free.
Then why it has not been admitted?
I thought it will be listed tomorrow for your lordship.
Yeah, for list over. Which matter?
That is the WA number 738 of 2024. There I saw that in all earlier DT applications they had made me party.
Never listed. So it will be listed. List this matter on 1 week. It has been stated that another intra-court appeal has been filed by WA number
738 of 2024.
Application has been filed registered as WA
738 of 2020.
738 of 2024. Questioning the same decision of the Supreme Court, of the relevant single judge, which is under challenge in the present intra-court appeal. I'll stop. On the next date, the court will consider whether the said appeal, whether appeal number so and so last one should be taken up with the present appeals or not.
Yes, ma'am. The Lordship, may I pray to call for the records?
No, no,
Where
no
civil
record.
court is settled
No,
over the matter.
no, sorry.
It is under question, Lord.
Sorry.
But whether the same pleading is making or not, for the interest of justice, it should.
Sorry.
Next.
Yes.
Item number 40.
Lord, I am appearing through VC.
Yes.
Lord, the writ petition seeks to challenge an award passed by the learned Labour Court. The learned Labour Court in the award holds that the termination is bad and there is an infringement of Section 25F of the Industrial Disputes Act. But while deciding the issue as to what relief should be granted to the workman, it grants rupees 30,000 in lieu of reinstatement. That is the subject matter of challenge before your lordship.
Who are you?
My lord, I am for the workman, the petitioner here.
You want more?
My lord, 30,000 when I have worked from 1/8/1991 till 27/1/1997. When there is an infringement, I say that the party number 2, corporation, is an industry within the meaning of Section 25N. In fact, identical matters, the industrial tribunal as well as
that is not in dispute. It's an industry. Therefore, your dispute
Oh, my lord, there is a thin line of distinction between Section 25N of the Industrial Disputes Act and to come under the purview of Section 2J of the Industrial Disputes Act.
25N.
25N.
Yes.
Because the corporation admitted that they are an industry within the definition of the meaning as laid down under Section 2J, but not under Section 25N.
Yes.
Lord, the condition under 25N is more than 100 or more. Now, if your law.
Yes.
If your lordship will just take 3 dates.
Which provision?
If your lordship will have just 3 dates. Section 2J, if your lordship will look at Section 2J, they agree that they fall within the definition of 2J. But not under the but not under 25N.
Industry.
Industry.
Yes.
Now, if your lordship will just note down 3 dates, 1/8/19.
So reading what? J?
three dates. 1/8/1991. Can your lordships hear me?
Yeah, the voice is not very clear, but still, we are on J, 2J. Then you want us to read what?
No, my lord, just 2J. They agreed that they are an industry within the meaning of the definition under 2J, but do not fall under section 25N.
Yes.
Now, if your lordship will just have three dates. 1/8/1991, the petitioner joined as a watcher under the opposite party corporation number 2.
You are referring to 3A.
My lord.
Huh?
My lord, my senior is referring to three dates.
Dates, 3 dates.
Yes.
All right. Yes. What are the dates?
My lord, 1/8/1991.
Yes.
The petitioner joined as a watcher under the opposite party corporation number 2. 27/1/1997, a notice was issued to retrench him from service. And on 21/1998, he was terminated.
Yes.
Thereafter, a dispute was raised by the workman, the petitioner, and the matter was referred by the appropriate government. And if your lordship will look at page 29, that is if your lordship, I'm not taking your lordships to the statement of claim and the written statement. I'm taking your lordship straight to the award. And if your lordship will look at page 19, the award starts at page 19.
Yes.
And if your lordship will look at page 20, that is the reference.
Yeah.
Whether the action of the management of Odisha Forest Development Corporation Limited, Bhubaneswar, in terminating the services of Sri Gagan Bihari Das with effect from 21/1998 is legal or justified. If not, what relief Sri Das is entitled to. Now, if your lordship will look at page 23, the Labour Court frames two issues.
Yes.
Whether the action of the management of Odisha Forest Development Corporation Limited, Bhubaneswar, in terminating the service of Sri Gagan Bihari Das with effect from 21/1998 is legal and or justified. Now, this issue has been answered in my favor. If not, what relief Sri Das is entitled to? Here, the tribunal grants only rupees 30,000 rupees in lieu of reinstatement.
Yes. So what do you want?
My lord, I am still unemployed. And I have years with me. If your lordships thinks fit, I need reinstatement. Otherwise, there has to be a substantial increase in because there are plenty of judgments of the Supreme Court where in lieu of reinstatement, the compensation should be much higher. Because I had years of service with me. And the IT Act doesn't discriminate between casual laborers or any laborers. Anyone who has worked for 240 days falls within the parameters of the Act. If your lordship will permit me, I'll just read the first. It is answered in my favor that there is a violation of section 25A, though the tribunal at page 25 says that there is no violation as far as the provisions of 25N is concerned.
Because you could not establish.
Yes, my lord, but I'll just tell your lordships that there were other workmen who went to the Labour Court or the Industrial Tribunal in respect of the same retrenchment orders, because some of them were retrenched in the same process. And they produced evidence which is at page 43, which I did not possess at that particular time. And if your lordship will look at page 43, It is clear that it is an industry within the meaning. Your Lordship will look at page 43. That document was not with me, which the other workmen had produced.
No, but the finding was in your case. Based on the evidence led by you.
The finding is in my favor as far as the first part is concerned, the first
Yes.
issue.
25 and the tribunal has specifically recorded will not apply because you could not prove.
Yes, my lord, but I'll tell your lordship that identically situated workmen went to the labor court and the industrial tribunal.
Your case was to be decided on the basis of evidence led in your case before the tribunal.
I appreciate, my lord, but can your lordship just have a look at page 43?
Yes.
Page 43, just have a look at page 43. This is the document which I could not produce at that time, and if your lordship will look at them, they have a surplus staff of 3,281. 3,281. So it's not a question of 100. They had staff in thousands.
See
But in any view of the matter, I will not bother your lordship with 25N. But when the labor court comes to a finding that there is a violation of 25N, the necessary consequence in most of the cases is
who is appearing for the corporation?
I am there, my lords. I'm appearing for the opposite party corporation, my lords. I am on virtual mode, my lords.
Please enhance the amount of compensation.
My lord, without recording my concession, your lordship may double the amount, my lords. I'll pay within 1 month.
60,000.
Yes, because your lordship may kindly see what my London friend
7 years I have worked.
Not side by side. Yes.
I'm saying, my lords, his salary was rupees 15 per day, my lords. That is in evidence. That is in his evidence that it is 15 rupees per day. Considering all those things, my lord, the London Labour Court has come to a finding that, and my lords, my learned friend said that the issue number 1 was answered in his favor. It's not correct, my lords. Your lordship may kindly see there has been illegal, or your lordship may kindly come to para 7. There, my lords, the section 25A of the Act by the first party management in action cannot be held to be legal, though the same found to be justified, my lord. The action is justified because, my lord, your lordship, in the year 1990, my lords, Orissa Forest Corporation, Odisha Similpur Forest Development Corporation, and Orissa Plantation Development Corporation, all are government corporations, my lord, they merged, and this Orissa Forest Development Corporation.
The finding is very clear. And it
My
says taking into consideration the length of employment under the first party,
yes, everything.
and the fact that his retrenchment from service is not in conformity with provisions of Section 25F of the Act, he is held entitled to some compensation.
Yes.
Right.
So I would have said 50, 60 or lots.
All at 75 we can do.
Corporation is in a bad shape. Anyway, I'm not there. I leave it to your lordship.
Well, Lord, I'm not going to join issues in that, but may I just pray, just humbly pray that this man has no job right now. I have met him. He's in a very bad situation. Can I just pray? I'm just praying. Can I pray that your lordship may direct an amount of rupees 1 lakh to be paid?
No, in that case, your lordship may kindly see this 25.
75, Mr. Mishra.
Yes,
very well.
That
very
is
well. Very well.
The petitioner has put to challenge an award made by the Labour Code Bhubaneswar
And my
dated
lord,
59.
Before your lordship dictate, can I just, because he submitted, my lord, your lordship knows 100 persons, if 100% are working in a factory, it does not come under section 22 chapter
No,
BB.
25 N, we are not saying anything on 25 N.
After that requires, my lord, it must be a factory.
Right.
Yes.
Yes. We will not say on that.
My lord, your lordship may enunciate.
Okay.
Without recording my concession, your lordship may enunciate.
Dated 39/2014, passed in industrial dispute case number 18 of 2013, whereby in an industrial dispute arising out of a reference made by the government of Odisha, the tribunal came to a conclusion that the petitioner's retrenchment was not in conformity, retrenchment by the so-and-so corporation management was not in conformity with the provisions of Section 25F of the Industrial Dispute Act. Stop. The Labor Court, however, held Labor Court held the petitioner entitled to compensation to the tune of rupees 30,000. Stop. Next. London Council, appearing on behalf of Mr. Mishra, London Council, Mr. Sivasis Mishra.
Both are S. Misra, my lords.
Therefore, appearing on behalf of the petitioner assailing the impugned order, the petitioner bracketed workman selling the impugned order has submitted that the labor court ought to have directed for a reinstatement in the facts and circumstances instead of awarding him compensation. Stop. He has further argued that the petitioner's case falls under Section 25 capital N of the Industrial Dispute Act instead of Section 25 F. Stop. He has made an alternative submission and has contended that in any case, the amount of compensation directed to be paid by the labor court is inadequate, and this court may consider enhancing the amount of compensation. Next. Mr. Somnath Mishra,
My lords.
London Council, representing the management, has submitted that it is evident from the award itself that the petitioner could not make out a case that the retrenchment was covered under Section 25 bracketed in of the Act because of lack of evidence adduced during the adduced in the proceeding before the labor court. First off, he has submitted that if the court considers enhancing the amount of compensation, that may be reasonable, keeping in mind the fact that the petitioner was getting daily wage at the rate of rupees 15 per day.
My lord, that is an evidence.
Lord, I have something to say here because if that has to be recorded, your lordship will look at page 26, last paragraph, 30,000 with 8% interest. This order was passed on 30th of September 2014.
All right.
10 years have passed. There is an 8% interest on 30,000.
So 60%, 60,000 plus 8%. That
My
will
lord,
be
you'll make it 50,000, my lord. So because
60,000 plus 8%. So considering the facts and circumstances of the case,
the award was paid by this
deem it appropriate in the interest of justice to enhance the amount of compensation awarded by the labor court to 60,000. Will you get more than 15,000? No, if your interest is, no, you will not get more than 75,000, we are saying.
That's the best option, my lord.
Lump sum amount of rupees 75,000.
Yes, my lord.
This writ application stands disposed of accordingly.
My lord, so within how many days, my lord?
Let the said amount be paid to the petitioner within 1 month.
My lord, my lord.
1 month from today.
Please pray for urgent copy so that I'll
Yes,
convey it.
urgent.
Item number 41.
Very grateful, my lord.
My lord.
The appellant prefer the city appeal being argued by the order passed dated 26 March 2021 in WPC number 24,676 of 2017. Before the Honorable High Court. In that order, the collector order has been set aside by the Honorable Court, which goes against the statute as well as law. Here the case is, the fact of the case that admittedly the respondents are not adjacent owner to the Chokor land. And so, and are also not availed any permission to sell the land or to purchase the land from the concerned Tahsildar. So violated very object and motto of the legislation.
Depends.
Mr. Mahanti, writ appeal is maintainable. This is
Certiorari proceeding. This is 27 is
consolidation.
Is a consultation.
Writ appeal is maintainable.
Not maintainable.
Is there any decision of this court on this?
Full bench decision
No,
is there.
that is with regard to 227.
Yes, ma'am.
Which come from CPC. So the consolidation authority is exercising the powers of.
Under here, they have exercised the power under section 34 and 35 of the OCH.
No, see, there are
Is this
in Allahabad High Court, this intra-court appeal would not lie.
Yes.
In Bombay also, this may not lie. In Patna, we do entertain. It depends on Allahabad has its own rules. Bombay also has its own rules. They bar specifically. If there is any decision that an application against the decision by the consolidation officer before this court lies under 227 only, then intra-court appeal will not lie.
The impugned order is passed under Article 227. If the Honorable Single Judge has exercised power under Article 227.
227?
Yes, ma'am. It's a writ of certiorari because there is a process of adjudication by the collector and the statutory power he has exercised and rendered the judgment.
No, then in every case that is done. Every tribunal, when we entertain, see any petition against an order passed by the tribunal which adjudicates, then according to you that will have to be treated a proceeding under Article 227.
That is a procedural proceeding.
There you also have said so far 227 and 227. Relying upon a judgment of Madhya Pradesh judgment.
I'm not saying that whether consolidation order arising out of consolidation.
Yogendra Singh ji case is, has clarified now.
Yes,
that
that has been clarified.
if the tenor of judgment of another.
So far as Consolidation Act is concerned.
Also usually entertain these are
Usually
usually entertain, but there is no judgment so far as consolidation is concerned. But 227, as you also rightly said, Allahabad judgment, Madhya Pradesh also have a judgment, full bench judgment. That judgment has been referred to in our.
No, but that is very, you see, Bombay cannot be equated with Odisha because they have different rules. Similarly, in Allahabad, they have rules.
Yes.
And in Allahabad, it is specifically mentioned that against this thing, if a writ petition is decided,
Article 247.
not 227, they refer to consolidation proceedings and these provisions. It is specifically meant. This is based on my memory.
I think
This is what I
particularly
recollect.
for consolidation matters, I think there is no
No,
decision.
Yogendra Singh ji, that is the last case. That is the latest case. Yogendra Singh ji case has said that if the tenor of judgment of learned single judge is
In the nature of
exercise of Article 227, even though he has not mentioned anything, then it won't lie.
Yes.
If it is 226, then only. Anyway.
No,
that is.
we should take up this issue, whether this rate appeal is maintainable or not.
Well, for the first time newly in this High Court, I have come with a single judge order, which usually.
So every single judge order you can challenge.
Which violates goes against, if the order goes in the statute.
So order is passed in criminal jurisdiction also. Order is passed in civil jurisdiction. Orders are passed in writ jurisdiction. So whether.
No, here my ladies, collector has rightly ordered, and I am supporting the collector, sir. That goes in my favor. But single judge relying on a decision, judgment, which does not appropriate to this case, pass the judgment. Like this judgment also I have attached. In that said judgment, my lord, clearly it violates the section 34-35 of the Act. And it says prevention of fragmentation. To encourage the cultivation of in our country, fragmentation to prevent the section 50 to provide that.
Of the Odisha High Court on this? Mandatory LPA? No, any view. Whether any view which has been taken.
My lord.
Just a minute.
Yes, Gram Panchayat.
Election, against the election dispute.
My lord sitting with Honorable Justice.
So many, in fact, education tribunal.
Quasi-judicial.
Another defect he, your lordship.
My lord, may I say, my lord, may I say, my lord, may I say about regarding mental liberty?
He is saying something defect.
The defect is there. He has included collector and Tahsildar as the appellants along with him. Your lordship may see the cost title. Perhaps due to
Have you taken,
oversight.
do you have a Kalatama?
That is not important. The main point is here in
No,
this
you
case.
have to correct the cost
I will
title.
correct, yes, I will correct. But the main point is that I will remember the defect. Section 34 and 35 of the Act is the treated to be heart and soul of the Act. And section 34, prevention fragmentation. Number 1, no agricultural land in a locality shall be
Please
transferred.
first correct your cause title.
My lord?
Cause title, please correct your cause title.
My lord, yes.
That was not pointed out very well, sir.
Here in the court itself I can.
They will be as pro
Your
forma
order.
respondents.
They are pro forma respondents.
So they can't be appellants.
Let.
Wrongly.
Because collector order either because
Manifest
This
from the
is wrong.
cause title.
My
That
yes.
the
Honestly.
that the collector, Katak and Tahsildar Salipur have been wrongly mentioned as appellants number
6 and 7.
6 and 7, who ought to have been implemented as pro forma respondents. Stop. Let necessary corrections be made in the cause title of the memo of appeal by Monday.
Okay.
Unless the appeal on Tuesday.
Okay.
Do it, correct it first.
Yes, Item 42.
If my will allow, I can correct here itself also the case. We can proceed with the case.
There, in the registry.
My lord.
Do it in the registry.
Item number 42.
May I pray? Clerks may take up this matter tomorrow. But that file is misplaced. I have requested my friend. Tomorrow I pray.
Tomorrow.
Or next week, madam.
As jointly requested, this matter on 1 week.
Item 43.
Eight. 137, the first pistol.
What about?
May I read, my lord? This court find in similar case though involving another department of the in disposal of the a coordinate bench of this court applying the decision through the secretary. State of Karnataka and others versus Umadevi and others reported in 2006 for SEC and State of Karnataka and others versus ML Kesari and others are directed for regulation of the service of the person involved. Then it is also found that the president has already worked for more than 23 years. In the circumstances, this court applying the principle indicated here observes that in the event the petition is holding a sanctioned post and he has already served as a temporary employee for more than 23 years without any stigma in his career, the case of petition for regulation of his service may be considered by the authority concerned in terms of the decision cited here by completing the exercise within a period of 3 months from the date of communication of certified copy of this order. Till such period, there shall be status quo in respect of the service position of the petitioner. This court here also directs in the event the petitioner is holding a non-sanctioned post, steps may be taken in sanctioning the post, keeping in view the long continuance of the petitioner as expeditiously as possible, preferably within a period of 3 months from the communication of the certified copy of this order. And this order was passed on the very first day, without giving us an opportunity to file a counter whether there is any sanctioned post or not, and to file an affidavit whether they are covered by our policy decision which governs the field of regularization. If we would have been given an opportunity to say they are not covered by our policy decision, as a policy decision is framed in compliance to the direction of Honorable Apex Court, so this direction would not have been given in the present facts and circumstances of the case. I have filed for my lord's perusal, I have filed a written note of last occasion, I have filed a written note of. I have relied upon the judgments of the Honorable Apex, which Honorable Single Judge has relied upon. And I have also given that
Who is appearing for the other side?
I'm not in this rate appeal.
137.
137, who is appearing?
Nobody has entered appearance, Your Lordship.
No, notices was served. Okay. No, notice was issued. What was the notice was issued, sir?
In fact, there is a noting, Your Lordship, that the counsel for the respondent could not accept the copy as he was impaneled as government advocate.
You are representing whom?
I'm appearing in
Then my
WA.
may say order dated 10/10/2022. First order was that to serve a copy. He did not receive. Thereafter, Your Lordship directed for issuance of the notice. Accordingly,
25
notice was
4
issued.
2023,
10/10/2022.
25 4 23.
Well,
There are two set, it is all tagged of matters were taken together. There are two sets of cases in this batch of appeals. The first is where the writ petitions have been disposed of on the very first day of hearing by the learned single judge without an opportunity to the appellant state to file a counter affidavit. The second set is where writ petitions were disposed of after pleading were complete.
yes, ma'am. So all
Since any event, this court would have to deal with the merits of the appeals in the second set of cases. The better course is for the entire batch of to be heard on merits by division bench itself.
Well,
Both the parties want more time.
well, in this case, all these batch cases, only two matters, except two matters, all cases there no counter was filed and verified. Respect of other matters on last occasion, Your Lordship has segregated that has been segregated from the list. And all these matters, except two matters, I will point out those two matters. In all the matters were disposed of on the very first day.
Mr. Counsel, so just see paragraph 2 of the order.
Well, well,
So the court observes that the merits of the case should be taken up heard by the division bench itself. So the question of remand or that doesn't arise.
no, but I am not, for that reason I have given the,
So,
well,
right,
for that reason I have given a written note of submission because I am, my challenge on two folds. First fold, we are not given the opportunity of being heard. Second fold, my lord, that they are not covered by our scheme. And also they are not covered by that judgment. Well, for that reason, I have given that written note of argument. And in that list, my lord has pointed out that in first case, notice was issued. Lordship may see my lord's order
Did you have any post Uma Devi policy?
Now, prior to that, we have a policy basing on the judgment of the Honorable Apex Court. That I have annexed that to Annexure 4 to my writ appeal.
No, but after Uma Devi, you were required to frame up your policy, no?
Yeah, there was a policy of our state that prior to Uma Devi. So we have not framed a policy in respect of DLR employees.
Mr. Kuntia, pinpointed question is, after Uma Devi, where the lordships have said that 10 years,
Yes.
even though there is no sanction post, one-time measure, you have to phase wise, take up phase wise
My lord.
and to take steps for regulatory.
My lord.
So that is what.
No, my, I have, in respect of sanctioned post, your lordship has seen that.
Admittedly, there is no
I have admitted that.
sanction of post Uma Devi.
And
Yes.
most fundamental question is that can we continue with the hearing of these appeals because other parties in other cases are not appearing?
That's the problem, my lord, because the others are not appearing. But in this, what I am pointing out, my lord, in this case, notice has been issued. So we are also missing my lord's order 10/10/2022. Notice, what a first order your lordship has directed me
In
to.
one case.
It's in all, some cases,
And other cases?
in some cases, they are appearing.
No,
If
we
your
have
lordship,
to- Otherwise, again, the same situation.
yes, my lord, again, same problem will arise, my lord.
Without hearing.
Yes, that I understand, my lord. If your lordship will permit me, again, I will take notice to them. Otherwise,
No, let us examine first as to notices have been served on how many.
yes, my lord, that's my lord.
In how many cases?
My lord. In first,
Notice control service agency appear coroner. Notice control service agency appear corruption.
You are appearing in how many cases?
I'm appearing on. 11 cases, your lordship.
And how many cases are there?
98 cases.
11 who are appearing.
Your lordship.
In other cases, I am giving the number, how many persons are appearing.
I'm appearing in one case.
I am also appearing in one case, and writ appeal 838 of 2022.
My case is 630 of Tuesday. Date of 630.
So let us verify in how many cases the notices have been served.
You can believe in a believe
You lord.
the numbers in which you are appearing. You are to the court master so that it will be easier for marking that.
We just want to notice as to in how many cases the notices could not be served and in how many cases despite service of notice, the parties are not appearing. Since you are there, we don't have any problem in those cases where all of you are here. These appeals on by Wednesday. By Wednesday it will happen. By Wednesday. Huh? Monday. Monday.
Hello.
They can verify and note it down on the soft copy.
Item number 44. My lord, I may kindly be permitted to mention one thing. My lord. In item number 43, in writ appeal number 838 of 2022, the respondent, as per my instruction, has passed away. May I be kindly permitted to file a substitution petition?
File a substitution for
Deeply approached.
You
for what?
You can
in 830.
You can appeal for the legal heirs by duly executing. You did not file any substitution petition. It is their appeal. How can you file substitution? You can only get yourself implemented by duly executed vakalatama by legal.
May I submit in this case 830 if you will furnish the details of, I can file an
Again, you
application.
will take notice.
I will file an application for substitution. If he furnish the details, the date, so that I can file instead of his filing, I can file, madam. Because this is my appeal, I will file, madam.
Yes.
Item of-
Note down that, Mr. Khuntia, you
Yeah, I have
note
noted
down
down.
that number.
Yes, madam, I have noted down.
So that.
I have not.
Let us go through.
Item 44.
Item 44, my lord.
There is some typographical error also in the order.
Number is
Order number.
Yes, my lord. There is a noting that there is
May pardon to mention, my lord. Lord, last occasion, your lordship have been pleased to segregate those matters. On the first of all, your lordship have directed for to hear on the point of limitation. So my lordship should first raise the point of limitation that we have in my 8 cases, 8 read appeal cases are there. In those 8 cases, in 2 cases, there are more than 700 days of delay and more than 500 days of delays. So I pray that the point of limitation should be first. My lord's leader should
May
present.
I drop my lord's notice page 74 is the impugn order. May I draw my lord's notice page 74, my lord?
Yes.
My lord, specific paragraph 3, my lord. It is agreed by the learned counsel for the party that the issue involved in this case is analogous to one involved in WPC number 33301 of 2020, WPC number 32900 of 2020, WPC number 3346 of 2020, and WPC number 33366 of 2020, which have been allowed by common judgment delivered on 11/12/2021 by this court. Therefore, in view of the detailed reasons stated in the judgment and order dated 11/12/2021, passed in WPC number 3330 of 2020 and WPC number 32900 of 2020 and WPC number 33346 of 2020 and WPC number 3366 of 2020, this petition stand disposed of in terms of the said judgment. Then you'll also turn to page 76. All these cases are disposed of in terms of the order passed in WPC number 33301 of 2020, which at page 76, annex 3, my lord. This order was challenged in WA number 687 of 2022.
Common judgment.
Yes, please. No, this judgment, in terms of this judgment, all the cases were disposed of. And this judgment was challenged in WA number 687 of 2022. If your lord, may I refresh my lords, that matter your lordship has heard it and judgment is reserved. Your Lordship may remember that case where they have passed from an institution neither recognized by the AICT nor from the state government. So, my lord, unless that matter judgment comes in that case, because all these cases are disposed of in terms of that judgment. If my lord hold that judgment is good, my lord, then I have no case in other cases. That will ultimately decide all the cases. So I pray all these matters can be adjourned after disposal of that writ appeal. These matters should come. This is my prayer. Because there is no separate order in respect of all these writ petitions.
Been submitted by learned AGA that the order dated 20/12/2021, which is under challenge in the present appeal, passed by learned single judge, is in the light of another decision rendered by the learned single judge in WPC number 3301 of 2020
And batch.
and batch. Stop. A writ appeal that is 687 of 2022 has been preferred by the estate against the order passed in WPC number 3301 of 2020, registered as WA number 687 of 2020.
22.
And 22, in which case hearing has concluded and judgment has been reserved. So stop. Next, this the matter on these matters on 3 weeks waiting decision in case of WA 687 of 2022.
Item number 45.
In item 45, I make a prayer for tomorrow because all the batch cases are there. My files are misplaced. Tomorrow, my lord.
Tomorrow, as requested. Day after government.
Item 46.
My lord, the time is taken tomorrow on behalf of Mr. Senate Council.
Tomorrow, as requested.
Each time he takes. Each time he takes.
Each time, Mr. How many adjournments have you taken?
Only one. All
They've
through government has
taken several adjournments.
I have not taken. 9 day government has filed the affidavit.
On 10/4, on 18/3, on 3.
Actually, my lord, I have taken a lot of adjournments. So to file that affidavit, which I have filed.
And could you find that rule?
There is no rule, my lord. That is my affidavit. That is my affidavit. That's why it took such long time.
This post is not available. It's no kind of facilitate in terms of the spinal injury center central government scheme. We have created that post and we have appointed. But in the counter, statement was made before the trial that following the new rules we have appointed. That has created.
So it should have been following rules, if any. Following rules, if any. Otherwise. Yes.
That is the only issue. Why is it?
When do you want? Tomorrow. Day after.
Day after I have personal difficulties, my lord. Let's come tomorrow.
Tomorrow. Tomorrow, because we have a standing committee meeting and we may have to sign the order. Therefore, we were saying, all right, it will come tomorrow.
Item 47.
Day after tomorrow I have personal difficulties.
All right,
that.
no issue.
Item number 47.
Your Lordship, on the last date, Your Lordship had allowed this appeal to be heard after the validity of Registration Act has been decided in another case, that is WPC number 16235 of 2016. This has not been decided as of yet. So the matter may be kindly adjourned till the
Lordship has directed that this case will be heard after the virus of that 22
That has not been considered. That matter has not been heard.
No, Your Lordship.
Maybe long date may be fixed. A long date may be fixed.
4 weeks?
Yes.
After vacation, you know.
6 weeks.
Yes.
Item 48.
Sit down. In item 48, a batch of cases, my lord. In some cases, in similar cases, we have approached in writ appeals. Those cases were dismissed on the ground of limitation. Those cases are challenged before the Honorable Apex Court. In a batch of cases, an order has passed on 14 or 16/4. That has not come, my lord. May I pray, because that order will govern some cases. May I pray your lordship may call this matter next week so that after.
As requested on behalf of the state. List this matter on 4 weeks or less than 2
Yes,
weeks?
ma'am.
1 week. So what is the decision in that case?
That exactly I don't know, my lord, because I could not upload that. That has not been uploaded. I have tried, my lord. In the morning, I have tried.
One has told that as read up, but unless we get it uploaded, we cannot also. One read appeal 369 of 2024 is left out. The same batch of matter, doctors of Ayurvedic.
In this case, may I pray, my lord, it can be segregated in 3 parts. I will give the letter, the chart will, I will give that chart.
This whole question for consideration, all these cases, the appointment prior to 1/1/2005, that is the date when the pension rules are released. Whether the contractual appointee or NMR employees or job contract employees, whether that period of service should be counted for the purpose of pension. That is the whole question for consideration. There are some judgment, division bench judgment, this court, and some matter they have gone to Supreme Court. My lord, in fact, on 16th court, some matters have been dismissed. But unless we see the order, we can't. So far as first matter is concerned, but it is not a contractual appointment. That post was advertised.
We will see.
On that day.
But that WA 369 of 2024 may be tagged with this.
Make a mention in the morning. We will make a mention tomorrow morning.
Item 49.
May I please, Your Lordship? Here, as per the last order, Your Lordship, the Director of Prosecution has filed the affidavit, Your Lordship, where he has stated that all the notices have been served except respondent number 33, Your Lordship, who left the job. And in para 4 of the affidavit, he has stated, Your Lordship.
Which order you are referring to?
And
you are referring to any order? Are you referring to any order?
4424 orders.
Oh, in the light of this order, 23/2024.
Yes, ma'am. I filed an affidavit. We have served copies.
Notices have been served.
Yes, ma'am. Except one, except respondent number 33, because she has left her job.
in terms of this court's order dated 23/2024 and 4/4/2024. An affidavit. So I said in terms of the order dated 4/4 in compliance of the order dated 4/4/2024. Read with the order dated 23/2024. An affidavit. Where is that affidavit?
Filed on my 12th April, man.
An affidavit has been filed.
Tag.
Mhm.
Not tag.
Yeah.
No, it is not tag. Not shown.
An affidavit
Physical
is said to have been filed on 12th.
April, man. 12th April. May I give that hard copy? E-filing. That was the e-filing. I'm giving that hard copy. E-filing.
Has been filed online on 12/2/2024.
12th April.
12th April.
12/4/2024. Stating therein that the notices of the presented appeal have been served upon all the respondents except respondent number
33, man.
except respondent number 33 who has left the job. So the said affidavit is not there on record.
I'm giving the order.
The registry submit an explanation as to why an affidavit filed on 12/4/2024 has not yet been tagged with the records of the present case. The explanation must be submitted by Thursday. Did this matter on Monday?
My lords, we are appearing for some of the respondents filed the wakalatnama that may kindly be taken on record.
File it.
May I please, Your Lordship?
Yes.
May I please, Your Lordship? Lordship, counsel for OP number 47 is present. We have also filed wakalatnama.
File your wakalat.
Filed, already filed.
All right.
Item number 50.
Please, Your Lordship. Yeah, why the
My lord,
not been tagged?
No,
Please,
50.
My lord, may it please your lordship. My lord, because of the urgency involved, your lordship, I have filed an IA number 4720 by 2024, which is at flag P of your lordship. Now the question involved for in this writ petition, your lordship, whether the persons, those who possess better qualification, whether any person, those who are possessing less qualification than us, whether they will be given preference over us or not. Your lordship, may kindly say the rule, 2013 rule is under challenge. My lord, may permit me to place page 33. I am directly taking to the part of the rule which is under challenge. Page 33, my lord. For the post of Junior Fishery Technical Assistant, JFTA. Now for the post of JFTA.
According to you,
my lord,
if there is a post of PN, now the question would be whether a PhD should be given preference or matriculate.
Yes, your lordship.
So PhD should be given preference according to you.
Definitely, your lordship. My lord, may kindly permit me to place. Even they have filed an affidavit that this is the matter which is required to be allowed and government is under active consideration. That
Now,
affidavit.
let us see.
My lord, page 33, your lordship. And with humble prayer, my lord, even if no preference is given, at least we may be treated at par.
Let us see.
My lord, page 33, minimum educational qualification. Point number 5.
Yes.
My lord, minimum educational qualification, it says the candidate must have possessed +2 vocational fishery from CHS.
Where are reading?
Point
Number
number,
5.
page 33, point number 5.
Yes.
Minimum educational qualification. This is for the post of JFTA, Junior Fishery Technical Assistant.
Yes.
The candidate must have, may I read, my lord?
Yes.
The candidate must have possessed +2 vocational fisheries from CHSE, that is Council of Higher Secondary Education, / University, and must know swimming well. Provided that when candidates possessing +2 vocational fisheries qualification are not available, candidates with +2 science qualification will be eligible for appointment to the post of Junior Fisheries Technical Assistant. Now, your lordship, we are all candidates having diploma in fishery. That's a 2 years full-fledged course provided by government. We are all having, after +2 science, we are having diploma in fishery. Your lordship, may kindly permit me to place paragraph 4 of my writ petition.
So whether you may be having diploma in fishery,
my lord,
you may be having post-graduation in fishery, but you must have this +2 vocational fishery for this post. This is what the rule says. What is wrong in it?
My lord, what they have stated, +2 science, they are having different subjects. Now, one subject is vocational fishery. Now, we have read +2 science. Thereafter, they allow us. They say that now they are treating us as +2 science students.
Yes.
The qualification we have acquired, that is after +2 science, this 2 years diploma. Therein, we have read, we have more subjects, and it's a better qualification. That is what the state has stated, my lord. This is a better qualification than a person having one optional subject as fishery in +2 science. Now, it is a 2 years full-fledged course. Now, a person who is having much more better qualification, he is given less preference than a person who is having lesser qualification. Your lordship, may kindly permit me to place paragraph 5, page 9 of my writ petition. I will not go through entire of it. Simply, I will submit page 9, paragraph 5. And I'll also come to
your eligibility is not in question because of 5.
If they are given the preference.
No, preference or eligibility, these are two different things.
Yes, your lordship. If we are treated at par with them, I have no objection. This is what the other states have done. If my lord may kindly see.
We will not go by other states. Please convince us of this.
Yes, your lordship.
We cannot lay down qualification.
We have no objection.
Page 20, you have enclosed the diploma in agro-polytechnic.
My lord.
Right?
My lord.
That qualification, you want us to interpret so that it is included in that clause 5.
It is included, that they have included. They say that +2 science, they are treating us as +2 science students. This diploma qualification, they are
They
ignoring.
are not treating you as plus science student. They are treating you as qualified in terms of the rules.
My lord,
Because you have ISC qualification.
my lord.
You are eligible because of ISC. They are not saying that you are ISC candidates. And they cannot treat you as vocational something +2 because that qualification you don't have.
If they are not available, then only they will.
Your lordship, probably I am unable to play. This is a post of junior fishery technical assistant, your lordship.
Yes, what is the state who is paying for the state?
My lord, I'm only your lordship.
We are making it clear that we don't interfere with the eligibility conditions, or it is up to you to consider.
Ma'am. This proviso is very clear.
We say that they are
Provided
eligible.
that when candidates
If-
possessing +2 vocational fisheries qualification are not available candidates with +2 science qualification will be eligible.
My lord, we are having +2 science qualification. Thereafter, we have persuaded 2 years of
You must
diploma.
have seen recent Supreme Court's decision,
My lord,
where the question was a minimum qualification was diploma in engineering.
my lord.
All right. The graduate engineers, they claimed that they had better qualification.
My lord.
The court held that no, since they have you do not have the diploma engineering qualification, you are not qualified, despite the fact that you have better qualification. So minimum eligibility condition is laid down based on the nature of job.
That is exactly, your lordship, my case. My submission before your lordship, the nature of job is
That
fishery
nature of
officer.
job you cannot decide. That nature of job government will decide.
Yes, your lordship. Your lordship may kindly see what the government has filed affidavit. Page 137. Page 137. This matter, when taken up on different ends, when your lordship permitted me to appear the examination, also them to appear the examination, they scored 19.5 and I scored 62.5. Now, in spite of scoring 62.5, I could not get the job because preference was given to the person who is having lesser qualification than me. Your lordship may kindly permit me to place page 137. This is the part of the affidavit filed by state government before this honorable court. Now, page 137, the second subpara I am reading, my lord. Even the state says that.
Page
137, honorable court's record. This is in court's records pagination, page 137.
Part of counter.
That is your lordship.
Part of counter.
That is additional affidavit filed on 29/3/2023. That is paginated as page 137.
Yes.
Page 137, the subparagraph I am reading.
Yes.
Accordingly, may I read? Accordingly, the proposed amendment to minimum educational qualification has been submitted to government in F&IRD department to include the diploma in agro-polytechnic fishery science. This is, we are the diploma. Diploma in agro-polytechnic in fishery science from OUAT. That is our university, my lord. Orissa University of Agricultural Technology or other agricultural university of the country. Provided when such candidates are not available, then the candidates having +2 vocational fishery shall be preferred. It is exactly, your lordship, what I said. They say that we will give you more preference than the candidate having +2 vocational because that is a part subject they are reading. Even your lordship may kindly see, that is what the director has written to them. This is the affidavit they have filed, my lord, before your lordship, that we must be given preference over them. And this is what they are proposing.
That is in future. But what about the recruitment which has already taken place?
Which is already taken place, I am absolutely not challenging. Then I am challenging the rule, your lordship, because if it continues, when a lordship is in session of the matter, they have published this notification. That is why, my lord, I have filed this IA. IA 4720/2024, your lordship may kindly see at flag P.
Yes.
My lord, at flag P, the IA, the notification at page 6. This is the notification regarding different posts, and for JFTA also, Junior Fishery Technical Assistants, on 30th of March 2024, they have published that 212 posts they are going to fill up. Virtually it is fill up. They are filling all the posts. Thereafter, no post will be left. That is at page 7. Page 7 of the IA, at serial number 5, my lord, Junior Fisheries Technical Assistant under the Director of Fisheries. That is 212 posts, and the qualification they have prescribed. May I read the qualification they have prescribed, my lord, at page 12. In sharp contrast to the affidavit what has been filed, they stick to the previous rule, and under the Director of Fisheries, they say we will fill up this post. Your lordship may kindly see what even the director has written. Your lordship may kindly permit me to place Annexure 6, page 57. That will clarify the matter. Page 57, Annexure 6. Now, page 57, Annexure 6 of the writ petition, I am only reading, your lordship, what the director himself has written. In this, may I read, my lord? In this context, I am of the opinion that it is a 2-year course after +2 science. The qualification awarded by OUT is definitely preferable over the present prescribed qualification, that is +2 vocational fisheries, +2 science, made under the rule. Further, +2 vocational fisheries course is almost stopped, for which the candidates could not be made available. Maybe that is a contingency they have stated. As a result, the +2 science candidates have been selected. Moreover, inclusion of diploma in agro polytechnic in fishery science as preferential qualification for the post of JFTA would no doubt strengthen the technical backbone of the department. Now, your lordship, any rule which is made is subject to test. If it is arbitrary, if it is highly arbitrary, if it doesn't even appeal to the conscience, then your lordship may consider that rule cannot stand. Now, we are persuading 2 years diploma science course after +2 science. It is a full-fledged 2-year science course. That is by the government authorities, OUT, it's the Odisha University of Agriculture and Technology. That is a course prescribed specifically for the post of JFTA, Junior Fishery Technical Assistant. Now, a person who pursues +2 science along with one only fishery subject, he is reading it as a part subject. And in paragraph 5 of my writ petition, I have clearly stated that around 30 subjects, we are reading more than them. And I have annexed the syllabus.
Why don't you take a decision? You have come out with an advertisement. See, you're the director, whatever the director writes, the director's decision is not the final
This
decision.
is only to supplement, madam. Only to.
Why don't you file your affidavit to this IA?
The traditional affidavit, para 5. Para 7, subpara. 137, page 130. You have already suggested. Accordingly, the proposed amendment to the minimum educational qualification has been submitted to the government to include the diploma in agro polytechnic in fisheries science from OUT and or other.
Why did such candidates are not available? The candidates are in +2 vocational fisheries shall be preferred and
That qualification he has. That qualification he has, and you are taking a decision. You have already suggested to the government.
And then you have started the recruitment process.
to that I will humbly submit. As long as this does.
What is the stage of the process?
Not yet started.
File 2 weeks time we are giving.
Then, your lordship, my prayer is that let it be.
What will happen within 2 weeks? This is what we want to know.
Your lordship, the process will start, my lord.
Therefore, we wanted, what is the stage? You said nothing.
Yes, Lord, I have annexed that on 24/4. The process starts on 24/4.
It's 24/4 filing of applications.
Filing of application.
Filing of applications will begin on 20th of April.
24th of April, my lord. 24th of April, the 24th of April 2024. The filing of application starts. My lord, why I am submitting before your lordship? I am only making a prayer. Last occasion during pendency of the case, they made an advertisement of 62 posts. I filed an IA before your lordship. Your lordship permitted us that you appear the examination. That order is there. We have appeared. Your lordship, what has happened? My lord may kindly see. After being permitted, when we appeared, page 125 of your lordship's brief. This is the result they have published. In page 126, your lordship may kindly see the cutoff mark. In UR category, the cutoff the person has secured is 19.5.
That you some.
And
already
I have secured 62.5. But I could not be selected because they are giving preference to him. Even your lordship may consider it doesn't appeal to the conscience. A person securing 62.5 with a better qualification will not be given, and the persons who are possessing less qualification with 1/3 of my mark got selected. This is the last advertisement. Now, if this rule, your lordship, again they continue, the same thing will happen. I only pray before your lordship that let it be stayed.
What is your qualification?
My qualification is a diploma, Lord, agro polytechnic. That is the same qualification.
Where have you mentioned?
That is paragraph annexures I have made, my lord. My certificates I have annexed. That is in paragraph 1 itself. And all my certificates also I have annexed. Annexed 1.
25 and
Where have
26.
you stated?
My lord.
25 and 26.
Where have you stated in your writ petition?
Paragraph 1, my lord. I am reading, my lord. Paragraph 1.
Look, the petitioners claim to possess diploma qualification in fishery science from Agro Polytechnic Center, Odisha, the Odisha University of Agriculture and Technology, bracketed OU 80 Bhubaneswar. They have put to challenge in the present writ application the validity of subrule 5 of Rule 5 under Part 3 of the Odisha Subordinate Fisheries Service Recruitment, Fisheries Service bracketed recruitment and conditions of service, bracket was Rule 2013, which lays down the minimum educational qualification. Full stop. The petitioners do have the ISC qualification also.
+2 science.
+2
Science.
+2 science qualification also. Full stop. Minimum educational qualification as laid down under Rule 5, under sub-rule 5 of Rule 5 of the said rules reads as under minimum educational qualification, paragraph 1 से quote कर दस. Assailing the validity of the said rule, learned counsel for the petitioners has submitted that the same is wholly arbitrary and discriminatory in as much as it does not give due weightage to the petitioner's qualification of diploma in fisheries. What is that? Diploma in fishery sciences full stop. He has drawn our attention to an affidavit filed on behalf of the state of Odisha, wherein which paragraph?
That is subparagraph, say paragraph 7, subparagraph.
Wherein from which it transpires that there is a proposal to amend the said minimum educational qualification relevant portion of the said paragraph is reproduced here and below. Paragraph 7, subparagraph, subpara, accordingly. Stop. It is his submission that even the state of Odisha has realized its mistake in laying down the minimum qualification. Stop. However, the state has come out with an advertisement for filling up of the posts of post of
Junior Fishery Technical Assistant.
Junior
JFTA.
Fishery Technical Assistant with the same qualification as prescribed under the rules without waiting for the amendment in the rules. Stop. The advertisement has been brought on record by way of annexure.
Annexure 14, that is in IA number 4720 by
Annexure 14 to IA number 4720 of 2024. Stop. Let an affidavit be filed on behalf of the estate within 1 week, informing the court as to whether the department intends to, the department intends to amend the rules as disclosed in the additional affidavit as noted above. Stop. This is for the reason that the stand of that the proceeding of the present case shall largely depend on the stand which the state takes in this regard. Stop. List this matter on 1 week. Do it.
May I pray, my lord, in the interim, your lordship, may
1 week, mister. Therefore, we have done it.
I make a
That is
small
for-
prayer, my
Before the last date of,
1
before
week.
the last date of submission of applications,
May I make a small prayer, my lord? Let the state file an affidavit serving a copy to me. Your lordship may call it after 1 week on any date. The matter may be finally heard and disposed of on that date because the matter is your
one
your
week
lordship.
we said,
We don't know.
1 week.
1 week within first 5 cases. All right.
Your lordship may call it at 2 p.m. on any day, my lord, after 1
Sir,
week.
we are saying it will come on after 1 week within first 5 cases. What
My
more do
man,
you want?
I am extremely sorry. I am extremely sorry, man. I am extremely sorry.
Don't we understand the urgency of matters?
I am
Huh?
extremely,
We were also lawyers.
my lord, I am extremely sorry. I could not hear it. I am sorry.
Item number 51.
Obliged,
In this matter, I am for the opposite party. In fact, the petitioners have challenged section 16(2)(c) of the GST Act. Similar matters are pending before your lordship may be taken up along with that. Because 16(2)(c) of OGST Act.
The GST Act, your lordship.
Along with that.
Along with? Okay. Yes. These matters are
Similar matters, my lord. All have challenged different councils.
16(2)(c) of the GST Act.
GST Act.
All are validity is challenged or?
All.
list these matters along with WPC number 13302 of 2022.
Lordship.
And batch.
In which case you have filed counter? Have you filed any counter
In this case, we have already filed the counter.
Here you have filed counter.
Yes, Lord.
The lawsuit had also directed the Tahsildar to remain present in the court ground. In fact, there was an agreement signed between the Tahsildar and the OP number 6 on the basis of which he had reported the amount. The Tahsildar issued a letter to the registered document cancelled so that the amount is to be paid to him.
The problem here is with regard to that cancellation of lease deed, the government should cancel the lease deed.
Yes,
So it is at their behest, the whole process is stopped. Now they are putting the ball in my court.
No.
Can you
I
see this
think
letter?
she has not informed. The Tahsildar made a requisition, reserved a slot before the sub-register, asked her to be present in the.
No, but the letter is different. Letter is different. Kindly see this letter. You are directed to cancel the, just see. Just see this letter.
Maybe language different.
And then
Slot has been issued.
kindly see that letter.
Slot has been booked by the Tahsildar.
That's right. But then kindly see the tenor of that letter.
Just a minute. I cannot decipher anything.
In fact,
All right.
But this slot was booked by the
All right.
Let me
Tahsildar.
tell the issue behind this. They want to avoid that once the lease deed is cancelled, the stamp duty will be refunded. Once it is cancelled at my behest, they will say that you have cancelled it, will not refund you. So that's the reason they want to put the ball in my court that you cancel the lease deed.
No, there is nothing in this.
Paragraph 1 is clear.
No.
Paragraph 1 is clear.
It is not that you at your instance they are cancelling. It is not that.
Last line kindly similar. You are directed.
No, you are directed.
First paragraph
Yes,
is
you are
that
directed to cancellation of your lease deed.
Appear for cancellation of there is some defective language. Yes, what do you want?
No, the lawsuit direct letter of your corporate. This is the slot booked by the Tahsildar. It shall be cancelled on that day. Immediately they have to pay half the amount. Only cancellation is required.
There is no problem. We will immediately appear. Let them.
We take it.
All right,
We
we will
will
take up the
record-
matter tomorrow.
Ajay,
His attendance will not be required. Personal, so and so is personally present.
Not a big deal.
Pardon to
Discuss
mention
the
that
matter tomorrow. His personal attendance stands exempted for the present.
Item.
Lordship, pardon,
Assistance with current. Huh?
pardon to mention, Your Lordship, in
Not now.